We can have it on 15th.
Lordship, next week I'll be out of station, Lordship.
Then thereafter,
Any day thereafter.
20th.
That's fine with me, Lordship.
20th I'll not be.
When it's convenient.
15th, my lord.
15th, he is not there.
Oh,
I'll
you will
be-
not be.
Kohima, Lordship.
The last week. Or you can have it in March. 5th of March. 5th of March.
Fine.
Comfortable?
Yes, yes. Yes, Lordship.
On the prayer of by Mr. E. R.K. Chaudhary, Liz, Deputy, SGI Solicitor General of India, lists this matter again on 5/3/2024. 5/3/2024 for hearing.
My lord, I may also be permitted to go to the records. I mean,
You can also give him so that we can cut the time short.
Yes,
His
no,
junior
I-
can
I
He'll-
can
he'll
show it to him. That's fine.
share it.
Yes, yes.
all right.
May I please, Lordship?
Hmm.
Also, I'd like to mention for listing, Lordship, this Friday,
What is that?
area matter, Lordship.
Huh?
A salary matter.
Salary. Give it to him. Any listing, if you don't require it today or tomorrow, give it to him.
My lord, my name was not reflected in the cause list.
Which one?
My lord, in fact, that was, your lordship was pleased to dismiss it for, my lord, non-prosecution. My lord, I have filed this application 2 weeks back, my lord. Can it be on Friday, my lord?
Yeah, surely.
All right.
See, we kept the matter till the last.
Well,
It's only after I rose
no,
at
no, no, no,
4:15 I had signed it.
No, no,
I have not,
actually nothing.
whoever came, I have immediately restored.
I understand, my lord. Right, sir. All right. Please, your lord.
I'd like to mention item number 23 and 24. It will be led by Senior Counsel, Mr. R.P. Sharma, but he is unwell, Lordship.
That, Mr. Mehdi,
Lordship.
on the prayer made on behalf of, you are not there? Yeah, you're there.
He's there. He are good last time.
Made on behalf of Mr. R. Dhod, Learned Counsel for the petitioner, and not objected to by Mr. S.K. Mehdi appearing for the respondent number 4. List this matters
On
again.
9th, my lord, 9th, my lord. 9th of my lord.
Because he is unwell, Lordship. He may-
19 to 2020.
19, my
You,
lord.
you have problem. When do you want it?
Well, this earlier, your lordship heard the matter, may only may dispose of this.
It's all fixed. It just come. I won't be able to give justice to them. All
Senior
full,
Counsel
full
will
pack.
argue, Lordship.
You can have it on that week starting 19th, whenever you want it.
19 of 19.
19 to 2020.
19, yes. 19.
Mr. Chaudhary,
I'm sorry, Lordship. 5 and 6 are connected matters.
5 and 6. Okay. 5 and 6. 5 and 6. Ekalage listing.
May I please, your lordship?
Hmm.
Your lordship, I beg to mention item number 13 be urgent for today.
Huh?
Urgent for today. Item number
I
13.
think you had given a
Yeah, urgent.
list. Your name?
R. Chaudhary.
On a prayer made on behalf of, you're praying on behalf of?
S. Das, petitioner.
On a prayer made on behalf of Ms. S. Das, on a counsel for the petitioner. List this matter again after 2 weeks. Yes.
May I please, your Lordship? I'd like to mention item number 38 supplementary. I would like to withdraw the matter.
There's an interim order, lordship.
No. You are for whom?
For the
They are-
petitioner.
Petitioner.
Yes.
Your name?
F.A. Ahmed.
F.A. Ahmed. Okay. Mr. F.A. Ahmed, Learned Counsel for the WBC, 38 WBC. F.A. Ahmed, Learned Counsel for the petitioner, and the instruction submits that he may be permitted to withdraw the writ petition. So permission, prayer accepted, writ petition stands dismissed as withdrawn. I had to, in view of the withdrawal of the writ petition being 7190/2023, no further orders is called for in the IA. IA stands closed.
Lordship, may vacate the interim order, lordship.
The interim orders, if any, stands vacated.
I am for S1 5, lordship.
Mr. Hart, also Mr. K. Kolita, writ petition only. K. Kolita, Learned Counsel for the respondent number 5 is present.
All right, obliged.
Item one, order will be delivered at 2 p.m. Top of the list, item two. Parhad.
Yes, Mr. Mondo, anything you could get?
Well, that constable case, my lord.
Huh.
Your lordship kindly see, my lord, my argument on that one point is delay, another, my lord, your lordship kindly the same set of allegation and same set of, my lord, evidence. Same set of allegation and same set of, my lord, evidence.
Hmm.
So, my lord, your lordship kindly that very case, my lord, that Ramlal. In fact, in that case also, my lord, it is petition allowed by the Honorable Apex Court, my lord. Same set of allegations, same set of, my lord, that is after 4 years, my lord. So here in my case, it is 6 years, my lord.
No, that year, 4 years, 6 year is immaterial. It
My
doesn't
lord,
matter.
no, delay, I'm just, your lordship
Delay.
kindly pointed on last occasion.
But my second question to you was, the criminal case, the facets that are there in the allegations are there in the departmental proceeding
My lord,
stood established.
no, my lord, your lordship kindly see, your lordship kindly
You
see
read
that.
read the charge again at page 14 once.
Page
14.
14.
Because your case is, one of your limb of argument is, because of my acquittal in the, I'll say honorable acquittal.
Yes, it's
In
not,
the criminal case,
my lord,
this proceeding cannot sustain. That's one of your arguments. My query to you was, the nature of allegations, although based on the same fact, is different. And by reading the statement of the lady, which is there in the appellate order,
my lord.
and you not having crossed her in the
No, that I submit, but why I'm not, yes,
here, that allegation of you meeting her frequently, corresponding to you leaving your job,
my lord.
tantamounts to a misconduct to that extent. What do you have to say on that? You read the charge once.
Yes,
There is no whisper here of 396 or 417 in the departmental proceeding.
my lord,
It's a conduct.
my lord.
What do you have to say on that? What
No,
decision
on
you
that, your lordship kindly see the departmental proceeding.
Hmm.
Is there in misconduct, is there any findings? Your lordship kindly see.
No, that's
Not a single line.
no, that's why a finding is not required. My question to you, why a finding is not
No,
required?
because I am not cross-examining the lady.
That evidence itself,
No, why I am not
It's-
cross-examining, my lord,
it's-
that I have explained.
Mr. You have filed a written statement.
Yes,
You have disclosed your defense.
yes, no.
Yes,
In written statement, my lord, I denied.
you check up the
Denied.
law. Check up the law. You will find that is the, because
If your lordship,
you know, I had an occasion to examine this same very aspect just before my elevation.
my lord,
You know that very well. And therein, these things came to my notice. So if you give your the WS, finished, that you have disclosed your defense and you have
No,
not even taken a plea.
no, when I cross-examine, that's why, that is the reason, that's why I'm filing application to, my lord, Captain Aviance, the departmental proceeding.
Because departmental proceeding and the criminal case,
No, based on the same
all
fact.
the same facts, but the allegations are both different.
No, if your lordship go by the departmental proceeding inquiry report, so what I'm submitting,
Enquiry report, page 21,
21 only one line. Your
one
lordship.
line, and that one
So
line,
far from the inquiry held, it is proved. Only that.
one
There is
line,
no distinct definite finding.
no, one line is enough in page 19 statement recorded. Because we'll have to read the whole thing.
Exactly. But it
What
is
do
the
you have to
duty-
say on that?
It is the duty of, no, if your lordship go by our department, the appeal and Assam Malad being conduct disciplinary appeal rules, definite finding has to be given. But that is not there. And your lordship, another question your lordship put me on that day, because while you were arguing that very interestingly, my lord, that criminal case also argued by me. And I have given an alternative argument, your lordship kindly see regarding 417. So I am not admitted. I have not admitted that I went there and even my lord, your lordship, assuming that is correct,
Let's come to the criminal case.
my lord. Criminal case, your lordship kindly see. Page, my lord. Page 35.
No, I got it. Here PW one is at page 4, para 4. Para 8,
Para 4,
para 8.
para 8. The moot question whether trial court was to whether there was a evidence against the appellant established regarding the section 376 and 470 beyond all reasonable doubt, merely because it was an agreement between the parties which appropriate condition DNA test, the learned trial court ought not to have held the appellant guilty on the offense under section 370 and 317 IPC. But it should be 413, my lord. IPC. It was only the allegation failure to accuse the appellant on the pay of the maintenance. That part. The victim laws FIR, thus if the maintenance allowance would have been paid, it will not have been any grievance at the part of the alleged victim.
So in the criminal case, the relationship is apparent.
My lord,
The relationship between you and the lady is
Right.
apparent. But the ingredients of 376 and 417 were not found.
not found. Yes,
But that doesn't mean that you had a relationship. And in the criminal, in the department proceeding subject, you correct me if I'm wrong. I had gone through that. Just take me out of this. The conduct of you keeping a relationship with her was the question.
my
Being a member of a discipline force.
lord, if anyone has a my lord relation with one lady, my lord, is it amounting to my lord special of a service?
That you
No,
have to
suppose,
argue.
although my lord, it is not been proved. but
That is your, that will be your argument on proportionality.
my lord, no,
That will be
that's
the
why
third argument.
I'm being dismissed from service, my lord.
That would be your third argument.
No,
But for that, you will have to come to the fact that, okay,
no, my
I
department.
had a relationship, whether that will undermine everything. So now you will develop an argument of proportionality.
No, that's alternative argument. my lord.
Alternative.
Your lordship kindly see that para 10, my lord. Your lordship on last occasion, your lordship pointed out that yes, you said that already for 4 months I was in jail. That's why 470, 417. Your lordship kindly see.
That I'm not. even
That I am
giving-
not, that is an
No, no,
alternative
no, that
argument
is
I have
your-
made. Even
That is an alternative argument like that you are taking now.
my lord.
That can never be held against you. That will never be
But
held
my
against you.
submission before your lordship, the basis of the my departmental proceeding under my lord allegation that I have not paid the maintenance,
Mr. Monto, you summarize your points one to one, one by one.
my lord.
First point.
So my submission before your lordship that the departmental proceeding based on a my lord my criminal case and all the allegations and the criminal case as well as department here same that evidence which was produced before the departmental proceeding and the criminal case
Witnesses.
are same. 3 are same at least.
Now,
There are four witnesses, not 3 are same.
in a department proceeding, barring one, others are immaterial.
Yes, except that victim. So my submission before, since my acquittal, it is honorably acquittal, my lord. So I am entitled to get back my service. My lord. This is that department, my departmental proceeding, the finding us are wrong, my lord. By virtue of that latest judgment, my lord, that is Ramlal case, my lord. In Ramlal case, my lord, that is also after acquittal, my lord, he filed an application. And that was dismissed by the Honorable High Court, my lord. Then went to the Supreme Court and the Supreme Court allowed disposition.
Okay,
That is my-
Ramlal, relies on Ramlal.
Ramlal and one more other aspect, my lord. Judgment, my lord, right place. It is
Ramlal is that 23, yes.
Ramlal, it is, my lord, they are decided on, my lord, 4/12/2020, very recent,
Okay.
very recent, my lord. In that, my lord, all other judgments are relied on, my lord. There is one important judgment, that is, my lord, 2006 5 SCC 446,
Party?
GM Tank,
Oh, GM Tank.
GM Tank.
GM Tank has been relied.
Relied in
Ramlal.
this case. Yes, my lord, your lordship, that did everything, my lord.
Okay,
So that's my submission, my lord.
Hmm.
So that's why, my lord, my dismissal order is, my lord, that is not sustainable.
So one more submission from you. That query of this court. That it is the conduct
My lord.
which is there and which is apparent from the criminal proceeding also.
My
What do you have to say on that? That query of this court, that the conduct which is there, which is alleged in the department proceeding, is
Conduct-
also there in the criminal proceeding.
criminal
But the ingredients of that allegation offense is not there.
My lord.
What do you have to say on that?
This criminal conduct, my lord, if you are assuming, my lord.
No,
that
not criminal conduct.
No,
a
my lord,
conduct
that-
unbecoming of a police officer.
I'm become, no, I'm not an officer, my lord, I'm a constable.
Anyway, discipline force.
That is, my lord, if it is, my lord, held against me, it is, my lord, disproportionate against me, but especially disproportionate, my lord.
So that will come when you're in your claim of disproportionate penalty.
My lord. Because apparently, yes, some relationships are there, some relationship is amounting to, my lord, dismissal, my lord.
Your argument would be that even if it is admitted that you had some sort of a relationship with Bamuni, it not having an effect in your service,
My lord,
this penalty would be disproportionate.
because, yes. Because I am denied in, my lord, WS, in denied in, my lord, in fact, my lord, I proposed to test for DNA. It was not been done. And, my lord, very interesting in departmental proceeding, my lord, that medical certificate was not produced. In, my lord, departmental proceeding, my lord. And, my lord, I actually in such a case, why I am cross-examining, in appeal, I have taken a point, my lord. I was not even, my lord, given any defending officer, my lord. I am a constable, my lord. I'm
Did you ask for?
My lord, from the appeal, I have came to know, my lord, whether I asked for whether this have to, I don't know, my lord.
Not-
But in appeal, I have taken a ground, my lord. In appeal, I have seen, actually, I am making this submission from my appeal. Your lordship kindly see the last para of my appeal, page 31.
No, I've seen that ground.
The above noted case in contested in court of the Honorable Session Judge Golaghat, the learned superintendent of police ought to have asked me to engage at this, ought to have asked to defense assistant. So I could have cross-examined PW because a person like my lord constable, he cannot cross-examine my
Were you given the copy of the inquiry report and did you file an submit any representation against that?
lord, yes.
Where is
That
that?
I am reading that, my lord. No, in fact, my lord, in my appeal, I have the clear ground I have taken.
No, no.
No, I have
Was a
given
copy
second-
of the inquiry report given to you?
Yes, then my lord, with a second show cause.
Hmm?
With a second show cause.
Where is
So
it?
I given a reply to the second show cause.
Where is that?
Second show cause, that is my lord, page 6, page 26, my lord.
No, second show cause is their reply. Where is this reply of yours? Because you submitted something.
Probably. Where is the reply of the second show cause?
That's what I'm saying.
That
Where is that
but
reply?
that is not with me, my lord. Where is that line is there, my lord.
That-
But
that's what I'm
thereafter
saying.
I file appeal, my lord. Because statutory appeal I have filed.
Now, what were the grounds you took there?
Yeah.
Any statement?
Yes, if your lordship go by page 29, it is my appeal, my lord, and appeal against the removal of service.
But there you have dealt with your reply, second show cause reply.
Yes. Very last para of my page 31.
No,
Page 31, my lord. The above noted case in contested in court of the Honorable Session Judge Golaghat, the learned superintendent of police ought to have asked me to engage a defense assistant. So that I could cross-examine the PWs in the departmental proceeding, but I did not. I could not cross-examine the PW.
but Mr. Monto, this is the stand with regard to not cross-examining the witnesses and not what you said. You said is a legal argument. But actually, that was not the point taken before the authorities.
My lord. But ultimately, lately also, my lord, in the appeal, my lord, it was taken.
In appeal, it was taken in the form that because of absence of a defense assistant, I could not cross.
My lord.
Not because that my defense will be disclosed.
No, that is also in my, there's a application I have filed.
No, that is rejected, deemed to be. Before the proceedings, you filed an application that session case is pending,
Ah.
so don't proceed.
My lord,
But that was not accepted. You participated in the inquiry. So
correct.
that is a closed chapter. You had projected that, see, I had taken this point that I'll be disclosure of my appeal. It's not disclosure of the appeal, but absence of a defense assistant.
My lord.
Both are different. Where is your that reply? That may throw some light. Yes, Mr. Bora, you have a record with you.
Record, my lord.
Can you just get that document? Second report's reply.
Take some time, your lordship. But only on the point, on last occasion, your lordship rightly raised this query as to the delay.
Delay we will look into, don't worry.
Yeah, because I want to place one judgment of division bench on this very issue.
Hmm.
Your lordship.
What is that?
Citation is 2012 1 GLT 317. Abhijit Chakraborty versus State of Assam. Thank you, Lord.
What are the facts? Facts
were-
means about the delay.
The whole, I'll just read out the question of law which was actually discussed.
Hmm.
As to whether the very pendency of the criminal proceeding can debar initiation and finalization of the department proceeding, and on conclusion of the same, whether a penalty can be imposed and whether the delinquent can wait till the outcome of the criminal proceeding will be discussed a little later. It was
Good.
discussed and paragraph.
Party's name, party.
Abhijit Chakraborty. The relevant paragraphs are paragraphs number 6, 7, 8, and 9. Therein, most specifically at paragraph number 8, I have highlighted that particular
Hmm.
portion. That issue was actually discussed in light of various Supreme Court judgments.
This is what I was trying to tell Mr. Monto the other day.
And in this writ petition, there is not even a whisper as to explanation and as to why they had filed this writ petition in the year 2013. The delay portion is missing because I just went through paragraph number 15 of the writ petition. That explanation is missing.
Hmm.
And with regards to the memorandum charges at paragraph number page 14, the facts of the criminal case were different and facts of the department proceeding were different.
I'll try to a bit modify that. Facts are the same. The projections are different.
Projections are different. I'm sorry, I stand corrected to that aspect. Because
Do one thing. Mr. Monto, anything more?
No, my lord, that your lordship kindly see the page 16, my lord, annex 3, my lord, in the, my first proposed reply. My lord.
I've seen it. That session case, fourth paragraph from bottom.
My lord.
Hmm.
I deny the charge in misconduct defense. I desire to be heard and personal.
Person adducing the of defense witnesses will be intimated in due course.
Intimated in due course.
So you said, come, proceed against me. You were very eager to have that proceeding done.
No, my
Anyway,
lord.
that's ignorance.
That ignorance,
That's
my
it.
lord, in fact, my lord, that in Lamlal case, my lord, everything is discussed, even that delay also. Because normally in this type of case, my lord, always, my lord, file an application after
I know,
getting
I
equivalent.
know.
After getting equivalent, even in my lord, earlier case also, that
also,
2006.
also I'd like to place this particular judgment, more specifically paragraph number 22 and 23, being a member of the discipline force,
Hmm.
a constable. If I may just read out. The citation is from AI 2016 SC 3131.
Para?
There are number 22 and 23. The learned counsel for the respondent has submitted that
Para? 20.
22
22. The Learned Counsel for the respondent submitted, even if the charges have been proven.
have been proven. The punishment of dismissal in the obtaining factual metrics is absolutely harsh and shocking to the conscience. It is in his submission that the punishment is disproportionate. The respondent was a part of the discipline force. He has left the campus without prior permission, proceeded to the market, consumed liquor, and quarreled with the civilians. It has been established that he had consumed liquor at the marketplace, and it has been also proven that he has picked up quarrel with the civilians. It is not expected of a member of the discipline force to behave in this manner. The submission, as I noted earlier, is that the punishment is absolutely disproportionate. The test of
Para
proportion.
23 would be more apt.
Yes, yes, I'm coming to that. also.
Need it,
I'm
not,
coming to that. Your Lordship.
don't read. Just show Mr. Monto that.
No, that is in different fact, my lord. Your lordship kindly see
See
that.
that para 23.
And my lord, constable, my lord, regarding this problem, I am submitting my
We
lord.
will consider. Mr. Bora, can you get me that?
Record.
Hmm.
Some time may be granted here,
Sign means, I can't grant you beyond Tuesday next.
Tuesday.
I'll keep it for delivery of orders on Tuesday. Just get me that. Second show cause notice. It was issued by Supanda Police Gulaghar.
Yes, your Lord.
They'll have the file. They maintain it very properly.
Yes, your lordship. That is why from Golaghat.
No, Golaghar, you put a WT message today itself. All of the. You find it at page 26.
Yes, your lordship.
Just want to see what his reply was. Because Mr. Montos, one of most argument is that the conclusions are not there, findings are not there in the inquiry. So we would like to see whether he had accepted it or not at that point.
My lord,
Anything more, Mr.
that's all.
I'll fix it for delivery of orders on 13. If possible, if you can get it on 12th. Mr. Bora,
Yes, your lord.
that page you can give it to him.
Yes,
The file will be with me. You can give it to him.
yes.
Mr. TJ Mohanton, counsel for the petition. Also heard Mr. B. Bora, learned counsel, appearing for the respondents. Also, the hearing is concluded. Oh, Mr. The matter, how is the hearing? Matter has been heard at length. Mr. D. Bora on the next day fixed shall place before this court the reply of the petitioner to the second show cause notice issued to him by the Superintendent Police Gulaghar wide communication dated 17/7/2004. Also, list again on 13/2/2024. 13/2/2024. Agreement, the understanding is I'll pass the orders on that day after perusing that.
My lord. I'll try to get it back, my lord. If I get, I'll place people.
Just a day before so I can.
My lord.
It will delivery of orders going. It will delivery of orders what काम करेंगे ना? हम ये रुको. Oh,
Develop.
it is my.
Oblige, your lord.
My lord, I have another item. My lord, I'll do it, my lord, but I little
Which one?
accommodation. Another item number 7, my lord.
Be comfortable.
My lord, because I have another matter I have to do and come back.
Pranab Sama, huh?
My lord,
Be comfortable. Be comfortable. That
that is also special, my lord. Industrial.
industrial tribunal.
Industrial.
Item 3. Pathak.
May I please, Lord,
Yes.
Lord,
What is the
yes.
instruction?
Lordship, already only one post, Lordship, under PWD category in political science department, Lordship, I have received instruction, Lordship.
How long has this post been lying vacant?
Well, Lordship, earlier, it was vacant, Lordship. Therefore, Lordship, principal has submitted this certificate, Lordship.
Yes, madam.
Lordship, this is the only last chance, Lordship, where I can be accommodated, Lordship.
No, it's a PWD post. We'll not touch that. Person with disability identified for.
I understand, Lordship.
When is your next vacancy arising in the college?
Lordship, we have no instruction regarding that, Lordship. Only this post, that's why principal has submitted this, Lordship.
Yes.
Lordship, respondent number 8 has also been legally appointed, Lordship. Same post, same qualification, Lordship, and that too junior to the petitioner, Lordship. Lordship, they have given appointment to this new candidate in 2002. They advertised this post, which was vacant, which was assured to the petitioner, Lordship. Again, they appointed a new candidate against that retirement vacancy, Lordship. Which is nothing but contempt of this court, Lordship. When there were specific instructions and direction of this court.
No, we have been our endeavor was to see that if there is any vacancy available to implement the orders of this court.
Lordship.
Anything more you want to submit?
Lordship, all I would want to say is that she has been denied since a long time, Lordship.
And she's
every time-
outside now. She's not inside.
Lordship,
She's not working.
sure, her appointment she was never terminated, Lordship, as such.
But she's not working practically.
Lordship, she was not allowed to work, Lordship. But there was no termination letter. So she is very much a part of the institution.
Okay. Anything more? Other than what senior has submitted and what you have taken me through.
Lordship, I would,
Any judgments?
Lordship, I have got a few.
What is it?
There's this Aravinda Kumar Sharma, for the state of Assam.
Aravinda citation?
Not managed to get this such. Hand over.
Yes, what is it? Yes, Mr. Gogoi. You find it out. You got it.
I have already submitted.
Just.
I explained Lordship regarding that case. Aurobindo Sharma case is a case, Lordship. It's a case regarding Lordship, the exemption of the net and slate part. There's a conditional regulation is there, Lordship. As per 17/7/2004 OM, where condition was input that Lordship, the person should comply the Lordship that net and slate part. That was decided by the Honorable Court, Lordship, in Aurobindo Kumar Sharma and 17 other cases.
They are the appointees under that OM,
OM, Lordship. They are adjustment under the 17/7/2004 OM.
Mizanur Rahman.
Lordship. And their claim is that, Lordship, that the condition stipulated in the appointment letter to be, Lordship, exempted. And they given the Lordship seniority from the date of their appointment, Lordship. The Honorable Court held that, Lordship, that the even, Lordship, the Honorable Court, one point of time in one paragraph says that, Lordship, even that particular very adjustment is against the principles of the Lordship, Honorable Apex Court, Lordship. As because government has taken a policy decision, they are adjusted, but they have to fulfill the Lordship required qualification net and slate, Lordship. And that 2 years period is given for net and slate, that was enhanced to, Lordship, 5 years period.
So that a subsequent approval was made to relate back.
Lordship, it is their lordship. They are the persons whose names were figured in the lordship 356 list, lordship. Otherwise, lordship, I have already submitted lordship after coming to post of
Give me a
the
small note.
statutory provision lordship
Hmm.
as per the golden principle of Nazir Ahmed Khan lordship and which was reiterated in the Mohan Singh case in 2023 HL Honorable Appeals Court lordship. We are unable to do lordship. We are bound by the statute lordship.
You give me a small note,
Lordship,
small note.
I'll provide.
Don't give any citation, just mark the citations will do.
No,
Don't
sir.
give any copies.
I'll.
Yes, madam, anything more?
All I would want to say is that this petitioner has been suffering a lot, Lordship. He has been, in spite of orders and directions from this court,
Madam,
Those which
that's
have
the
been-
reason why this court, although being placed with the law existing, was trying with the college authorities to find out some middle path. And that is these are the exercises which this court undertook.
absolutely,
We'll try,
absolutely,
we'll try.
much obliged.
We'll try.
I'm appearing for the respondent number
Hmm.
8, man.
Hmm.
Lordship, may kindly find the affidavit filed by
No,
respondent
no,
number 8.
you filed an affidavit. No.
My lord, in the affidavit, page 10, my lord.
Hmm.
After passing of the order in favor of the writ petitioner, I have approached this honorable court, my lord.
Hmm.
And this honorable court, my lord, may come to my lord, page 15. It is,
Running page?
uh, my lord,
Okay, no need.
The affidavit in opposition, page 10 is the order, my lord. Passed by this honorable court and.
86. No, page 10, internal
Yes.
page 10.
Yes, my lord, internal page 10.
You were holding a non-sanctioned post, that's
Yes.
why the court did not interfere with
Yes,
you.
and my lord, court.
And thereafter, what happened?
My lord, thereafter, my lord, the petitioner post was regularized in a personal post, my lord, that is at page 16, my lord. Page 16, my lord, English 3, my lord, the incumbent working under non-sanctioned post and who is adjusted against the post. He will be personal to the incumbent and automatically be abolished after retirement of the incumbent concerned, my lord. This is a personal post, my lord. My lord, this honorable court in the order specifically stated that, my lord, how the things has to be done, it is already stated in the order, my lord. So therefore, there is nothing that the petitioner will be dislodged from his post, my lord, for accommodating the petitioner. In paragraph 14 and 15 are the observations.
You also, Liberty, give a small note, whatever you have to say. Hmm? When can you give me a note? Note. I don't want the judgments, just give the citations.
So, tomorrow, day after tomorrow.
Give it to me by 9th. Let's this matter again on 13/2/2024 for delivery of orders. Okay.
Much obliged.
We'll see what we can do, maximum.
Item 4.
Yes.
Lordship, against the dismissal order in the departmental proceeding, Lordship.
Huh. He was some assistant manager, some FDs were there with the
Yes.
college
Yes, Lordship.
and done with. Being a bank employee, whether his pleas can be considered by this court.
Lordship.
That's the issue. But who is for the petition? Lost interest. Lost interest. We'll try after some time.
Lordship.
Or do it like this. None appears for the petitioner on call. I'll not dismiss it on mail. None appears for the petitioner on call. Mr. J.K. Goswami, additional senior government advocate, is present for the respondents. So,
Lordship, standing council.
so sorry, standing counsel, Apex Bank is present. Matter stands dismissed for non-prosecution. I'll not sign it till 4:50. Lordship. You don't need to go there. Lordship. যদি আহে কোনোবা, যদি কোনোবা আহে, নহলে ৰাতি গধূলি dismiss কৰিব।
Item 7.
Mr. Roman, you are waiting for which matter? Huh?
Item 20.
12,
20.
20. The respondent is there,
I am responding.
or petitioner? You're not keeping well, you should not be here, we can. Item number 20. If we can get the petitioner, we'll pick it up, don't worry. Yes, item number 7.
Please, your lordship, lordship, this matter may kindly be taken.
Mr. Chaudhary, he has some personal difficulty.
We'll wait.
We wait.
Obliged, lordship.
Item 8.
Lordship, this matter has become infructuous. The person already tried the petitioner.
Sure.
Yes, Lord.
Has to be, my lord, now
No, but
11 years.
his promotion was the issue here. So he is asked you to
Yes, Lord.
instructed,
Yes,
surely,
yes.
on the prayer
behalf
of,
P. Hazarika, Lord.
on the prayer made on behalf of Mr. So-and-so, your name?
S.S. Bora,
H.S. Bora appears on behalf of
P. Hazarika.
T. Hazarika, learned advocate, who is under instruction to pray for, who under instruction submits that the matter has since become infructuous.
Yes.
Infructuous also. Accordingly, the writ petition stands dismissed as being infructuous. Are you sure?
Yes, Lord.
Fine.
Item 9.
Nothing Anganwadi worker at that point of time.
Exactly. And it was
Same.
established also.
Dismiss for default query. None appears will query. Mr. D. Bora appears for the respondents. Somebody comes, we will take it up.
Item 10.
Yes, Mr. Bora. Who is appearing against you?
Mr. K.K. Parasar, he called me up yesterday evening.
Hmm.
He told me that he is in this case.
Hmm.
So I just called him. So
Let him come.
let him.
We'll take it up. It's a department proceeding matter. I don't want to have
Yes, sir.
one go, we'll have to go.
Yes, sir.
Item 11.
Yes, madam.
Your lordship. Lordship, the petitioner was appointed as a assistant teacher in the year 1998, lordship.
Honorary teacher.
Lordship.
Hmm.
But lordship, he was appointed by following a due process, lordship, because I have annexed the Halan lordship, whereby he participated in the selection process. Page 17, lordship.
Hmm.
Thereafter, lordship, at that time, there was a notification whereby it was decided to extend the benefit of reservation to the sons or unmarried daughters of retired teacher from primary to school level teacher. Page 18, lordship.
Hmm.
There is a notification. Thereafter, lordship, page 22, there is a letter, lordship, issued by the then headmaster to the inspector of school with a prayer to consider the case of the petitioner and appoint him in resultant vacancy.
Okay. Where is the select list of 1998?
Select list, I have not.
Where were you appointed in Barzola? High school?
School, Lordship.
Okay, then what happened?
Thereafter, Lordship, I had preferred a writ petition before the honorable court,
Hmm.
as nothing was done. And there was a direction to consider the case, page 27,
Under the 10% quota.
Lordship, there was a
Okay.
direction,
Now, this direction,
Lordship,
come to page 28.
Lordship. Page 28 is the operative part.
Hmm.
Lordship. With a direction to the respondents to consider and dispose of the applications representation submitted by the writ petitioner in accordance with the provisions of the law, along with the other similarly situated
Hmm.
candidates of the same category
Hmm.
within a period of 3 months from the date when a copy of this
So
order,
this would be this would mean that now you will have to be appointed under that 10%.
10%.
Okay.
Thereafter, Lordship, there was an order of the Inspector of Schools, that is a compliance order, Lordship.
Hmm.
Pursuant to the order,
Hmm.
I was adjusted against the transfer vacancy due to the transfer of Sri Malik Sarkar, page 29, Lordship.
Hmm.
That is the order.
Hmm.
Again, thereafter, Lordship, my salaries were stopped.
Hmm.
And prior to that, Lordship, another order was passed whereby my services was adjusted and regularized, Lordship.
Hmm.
That is page 31. Two orders was there after the order of the Honorable Court. And page 32 is another order of the Honorable Court, which I had approached due to non-payment of my salary, Lordship.
Hmm.
And at that time, there was a committee formed to consider all those cases.
Hmm.
And the order of this honorable court was to submit a case of the writ petitioner to the state expert committee for its examination. Now, the respondent authorities, what they did after 7 years of this order, Lordship, order of this honorable court, in the year 2014, they had passed the impugn order, which I have put to challenge in this present writ petition.
Hmm.
That is at page 34, Lordship.
Type copy.
Lordship.
Okay. Now tell me your points.
Lordship, firstly, Lordship, there was an order of this
Your date of appointment is
98, Lordship,
date, pura full date.
2/11/1998.
Hmm.
Then the notification of the 10% reservation quota,
No,
that is of 20,
98,
Lordship,
when you were appointed.
Lordship,
You were appointed by whom?
by the managing committee, Lordship.
Managing committee. When was the school provincialized?
School was provincialized in the year 78, Lordship. I think that is given in the.
Yes,
affidavit,
it's
Lordship.
there in the affidavit.
Lordship.
Respondent number 2's affidavit.
At that time, the school was provincialized.
So
when I was
how
appointed.
how could you have been appointed in 78?
But the process, Lordship, that is following a due process. I have annexed the Salan, Lordship.
Challan will not do. How can we believe on the challan when the committee gone into
But
its?
letter, Lordship, letter,
Okay, tell me. You were selected. Let's give you that. You were selected.
Lordship.
How can the managing committee appoint you? It has to be appointed by the appointing authority if you're a selected candidate.
But at that time, Lordship, the managing committee used to.
No, cannot. There is a decision of this court in a provincialized school. You cannot. There in the pleadings, it's there.
But
Respondent
I
number
had
2.
appeared in. the
Abdul
interview,
Bari's case, it's reflected.
Lordship, that is in.
So if your initial appointment is bad, 10% quota subsequently withdrawn. I think there is an order. I passed an order.
Yes.
That
Have
was
that number.
withdrawn. That notification has been withdrawn, Lordship.
You have a number. That number, case number.
Case number.
That is gone.
Lordship.
Then what is left?
Lordship, page 22,
Hmm.
Lordship, the headmaster had himself stated, Lordship, that again, he appeared in the interview of the district level.
Headmaster
selection-
is none but your father.
Lordship, he's my father, Lordship.
Yeah.
And he was selected by the board in 19.
He. So if he is selected by the board in 98, select list is of 98.
Lord.
98, that select list is gone. 99. 1 year. You see the rules. 1 year. In 2000, how could he write this? And all the appointments that after made are all honest.
And Lordship, there was an order of this honorable court.
This
also.
honorable court, 10% quota, if there is a selection you pass, you get it.
Okay.
Without a selection, you can't. Can you just get hold of that?
Working.
I'll find out. In fact, that notification of 10% quota itself clearly says
Huh,
it has to
there
be
are no
according to
selection.
merit.
And there are judgments of this
Yeah.
court. I followed one.
But my services was adjusted thereafter by the inspector of schools. The
Inspector of schools has got no jurisdiction here to do that. That's
But
the,
that was a compliance order, Lordship.
No.
Person.
there was no compliant direction of that nature passed by this court. You show me that there was a direction passed by this court to pay you salaries.
consider my case, Lordship, that was the direction.
Consider your case means what?
I was working, since I was working there.
What is the consideration sought? What are the premises in the consideration sought?
Of the applications, Lordship.
No, madam. What is the premises? Premises is 10%. So that did not occasion. So how could this page 29 have occasion?
Since I was working and there was a vacancy, that was.
Okay, that is
adjusted.
your case.
Lordship, that is
Okay.
the case.
Okay.
And the impugn order was passed after 7 years, Lordship. I've been working during that period. The order of the Honorable Court was of 2007, and the impugn order was passed after 7 years, Lordship, after a long period of time. That is another ground, Lordship.
Anything more, ma'am? And if you come to page 29, your adjustment is against a vacancy of some other school
Lordship.
with effect from 1/3/2001. And that has been dealt with in page 34 impugned order. Findings, first paragraph, last line,
Lordship.
right?
Yes, Lordship.
The inspector of school so-and-so also withdraw the said so-and-so. Petitioner so-and-so. Because the inspector of schools is not the competent authority to withdraw one post from so-and-so. The blatant violation of so-and-so. P. Colita, so-and-so reported a teacher appointed is not eligible to get pay. And hence claim of the petition is not enabled so-and-so.
Lordship,
What is the error there?
Lordship, the inspector of school is not competent enough according to them.
No, forget it. It's not competent enough because your initial appointment, which he is adjusting, is an honorary appointment. You see the order. Except expert committee has observed that since the okay, anything more?
Also, Lordship, the last paragraph of the impugn order.
Hmm.
Moreover, the committee also directed to the GSC Assam to take action against the erring officials who have irregularly appointed. There was a
And regularize that.
direction, Lordship.
So we'll direct them to continue with this action. No problem, including your father.
Lordship, he have retired.
Maybe, but if this direction is to be implemented, he is the one who initiated the whole thing.
Lordship, that was done.
We'll pass
as per-
orders, don't worry. We'll pass orders asking, saying that you had demanded this and let them.
Lordship,
proceed.
inspector of schools have done.
No. Your father started it.
Gave a hope.
Your inspector of schools took it forward.
Lordship,
But initially is your father.
Lordship,
We'll not say father, we'll say the principal at that point of time, headmaster at that point of time. You want this court to proceed on that lines?
no, Lordship.
Then we'll not. Yes, Mr.
But the petitioner claims that she was appointed, my lord, in the writ petition para 3, pursuant to a selection.
Hmm.
There is no select list, there is no appointment order.
Hmm.
Now, if your lordship kindly take up our affidavit, my lord.
Hmm.
Para 5 is our step.
Hmm.
Mary. The deponent begs to state that the father of the petitioner was the headmaster of the so-and-so school. He retired from service on attaining the age of separation on 30/04/2021. Thereafter, the petitioner was claiming for appointment against the reserved quota of 10% for sons and daughters of the retired government employee. That the petitioner approached this court, Honorable Court wide WPC number so-and-so, praying for his appointment, and this Honorable Court wide order directed the respondent to consider his case. However, the inspector of school wide order dated allowed the petitioner to draw monthly salary against the transfer vacancy, and subsequently his service was adjusted and regularized wide order dated 3/8/2005. In pursuance of the Honorable Court's order, however, there was no such direction for adjustment, regularization of the service, and payment of salary to the petitioner. It appears that both the orders were issued illegally, and therefore the salary of the petitioner was stopped. The petitioner,
I got it.
so these orders will not confer any right upon the petitioner to claim.
So that we did it based on the green. I'm keeping it at 2. We'll pass orders at 2.
Well.
Keep at 2 to put it in a labor temporary. Malang. Taking your motion to motion down.
Well.
At 2,
Nice one.
we'll pass the orders.
Item 12.
Yes, Mr. Goin.
Matter regarding my
Hey, order to upload it.
family pension.
That family pension matter,
my lord.
order you have
Yes.
uploaded.
Yes.
Okay. Yes,
Well, same matter, my lord. Squarely covered. Here is also.
But here, my lord, petitioners terminated in the list of terminated teacher 752, my lord.
where is the order of termination? Service of termination.
Lord.
Service of termination of not termination. Show cause notice. Yes, what is your case here?
My lord, they are appointed, my lord, in the year 1989, my lord. Subsequently, their service was regularized and confirmed.
Hmm.
And my lord, in the year
Okay.
2015,
okay.
they are.
Just a moment, just a moment. Where have you stated?
My lord, my lord.
No. Where have you stated in your affidavit?
My lord, para 5, my lord.
Para 4 also.
My lord. As may I read, my lord? On the basis of the report submitted by the district elementary of Dharmaji, the deponent begs to state that the husband of the petitioner appointed in December 1989 by the deputy inspector of Dharmaji State Division, now retired, against non-existent post without following selection process. As a result, there were a number of teachers, including the petitioner, terminated from service as per direction of the authority violated dated as their appointment were made against non-existing post. Initially, such teachers were paid salary for
Mr.
29
Goy, what is the other case number which I disclosed?
1726, 2017. Rinku Moni Sutia.
Rinku Munishuti. Pachila? Who does it? Right? Who do it? Upload police.
81 to 24.
812. No, it was uploaded subsequently.
Yes, my lord.
Okay, where is your statement that these orders were not served on you, husband, your husband? Specific categorical statements, like it was there in the other case.
Four, my lord.
4 I'm
Para
reading.
4.
Okay. Be it stated here, however, at no point of time their husbands were received with any termination. There are more than one petitioner here.
Yes, my lord. 2 petitions.
Why together? I do like very well. Okay, para 4. And para, next para?
Para 11, my lord.
Okay, let's see the reply. Para 4. Oh, it's A general reply.
My
Yes,
lord,
my lord.
more specific replies to.
The defendant states that
In compliance of the direction.
But in your other case, there was no reply. Right?
Yes.
And where is your regularization order?
my lord, page annexer C1. Page
Page
22.
22. And you are being paid salaries till August,
August 2007.
August 2000. In both the cases,
Yes,
in both the,
yes, my lord.
for both the petitioners.
Yes, my lord.
When did the petition number one's husband die?
On my lord, 8/5/2015. And petitioner number 2, 11/6/2015.
When was this termination affected, Mr. Borak?
My lord. Date is my lord. 1992, my lord, directed the authority to file letter dated 12/5/1992.
No, when did you pay them 29 months salary? That's subsequently.
My lord, with effect from
Same thing.
December 1989 to May 1992.
Same thing.
My lord,
That same with 17. What was the number? 1726, no?
Yes.
Hmm?
Yes.
17. Earlier case number that I disposed of.
1726.
Of
2017.
We'll pass similar orders, Mr.
No.
Dispose of.
obliged.
Supplementary cost list for motion item 37.
Lordship petitioner, Lordship, she was serving as a teacher at Longfetter English School, Lordship. She became pregnant on 9/11. She could not go.
I accept everything. Very pathetic. This is totally wrong. Should not have been done.
Lordship.
But how can this petition be entertained by this school? It's a private school.
No, Lordship. It's a run by the administered by the Kargil Autonomous Council.
No.
It's aided by the Kargil Autonomous.
No, it is not a provincial, I have the instruction, it is not a
It's
provincial.
only under the process. It's just a,
Non-government educational.
it's a. Have you registered yourself? It's not a provincialized school.
Not a provincial.
It's not a provincial.
Then have you registered yourself under the non-government educational institution school?
But
Is it
it is
registered?
recognized by the Kargil Autonomous Council, Lordship.
How? Where can you show?
Because they pay the salary, Lordship.
No, my lord.
Kargil-
I have the instruction, my lord.
Kargil
It is
Autonomous Council pay the
it is
fixed
not a
salary.
provincialized school, my lord.
And do you pay the salaries?
My lord, that is the
They pay the
managing
salary.
committee, my lord. We are giving the grant, my lord.
Okay,
Yes.
We are giving the grant.
In fact, Lordship, the grant in aid, the rule which says Assam aided middle English school, that also says that, in fact, if someone is to be terminated, a show cause has to be issued. The rule is very clear. They are not following anything, Lordship.
Only my question is whether this court would have jurisdiction to
Because
this
it is,
matter.
it is under the control of the Kargil Autonomous Council.
No.
And they being the position of a
Okay,
state.
where you be appointed by the Karbi Anglong Autonomous Council? Is there any approval of the Karbi Anglong Autonomous?
Yes, approval is there, Lordship, at page 20.
IS, that IS letter.
Yes, Lordship.
That is normal.
the deputy inspector of school,
That is neither here nor there. Come to that.
page 22, Lordship.
This
Action
is for
taken by
your,
the-
that provincialization purposes, this will be required.
Lordship. But this
So-
is the approval of the school.
And tell me, when was the school established?
Lordship, that information I do not have. Only the respondent council can.
How long you have been working there from 17?
17, Lordship, for the last.
One
7
thing,
years.
tell me, where your case is considered for provincialization? This Provincialization Act is not applicable to you.
My lord, initially that complete bar was there under section 2ZD, my lord.
Hmm.
But subsequently government issued a notification in 2023, my lord, implement giving effect the Provincialization Act 2017 to the Autonomous Council.
So was they teachers of this?
My lord, it's not a provincial school. I have the instruction, my
No,
lord.
no, I know that. They are venture or private?
They're private, my lord.
Private, not
Private,
even
my
a
lord.
venture.
Only the giving the, we are giving the grant only, my lord.
Grant to the extent of what?
To the annual grant, my lord, only to the.
No, no, to, it covers what?
My
All full expenses.
No, my lord.
That's
Certain
a very-
amounts only, my lord. Certain amounts, my lord. Those who are applying for the grant.
So you show me the law.
And my lord, the
The
educational
salary per
tribunal
day
is
of
there.
the Lordship.
Your grievance is not against the
tribunal is
Cardiac
there, my
Autonomous Council. Your grievance is against the
Against
management.
the school managing committee.
Then school managing committee, how will you have? The latest case, St. Mary's School.
St. Mary's School, Lordship, it's a completely private school. This is.
No. Supreme Court decision
Lordship.
on this topic. If you have any grievance, you will have to go before the tribunal,
Lordship.
education tribunal.
Lordship, the illegality is
Hmm?
illegality and
Illegality, first we'll have to have jurisdiction. There is illegal activities happening all around. Can we enter into all those? When we have a
the
defined,
resolution, Lordship, the resolution was passed by the secretary. Secretary is the headmaster who is appointed by the Tribunal Autonomous Council.
show me that,
They are being paid.
show me that appointment of the
That
managing
appointment-
committee is by the,
That I do not have at this
Then-
moment, Lordship.
merely saying will not do. You will have to bring on
Because the
record
appointment-
materials.
Appointment
If you
approval.
can show that the school is under complete control of the Autonomous Council, fine, I am with you.
They are the authority. who are
Because
paying the fixed salary.
If you can cross that, you have already made out a case for interference,
Lordship.
but you will have to cross that.
In that case, Lordship, may kindly fix it tomorrow. Let me take instruction whether.
Do it.
Lordship.
We'll have it on 9th.
Lordship.
9th.
Lordship, can it be on 8?
Huh?
No, 8. Can it be on 8, Lordship?
8, no problem.
Well, 8 is the month, 7 is our holidays there, my lord, to get the instruction about what is the grant received. my
You
lord.
have any problem on 9th?
Lordship.
And then next
Any
one,
problem on
Monday, my
9th?
lord,
Yes.
Monday,
Then Monday,
Monday,
Well-
one.
Lordship.
don't worry about the delay. If you can cross that,
My lord,
we will come in
12 months.
on the prayer of the Learned Council for the petition. List this matter again on 12/2/2024.
Obliged, Lordship.
Yep. All of this, thank you.
Order stay vacating item 14.
Please, your lord.
Hmm.
Your lordship will pick up the I interlocutory application 2118 of 23.
Hey, Okay. We are taking up the I 2118.
Yes, lordship.
Yes.
My lord, just to start with and give a brief overview, on 39/2000, the respondent number 7
who is the interlocutory applicant number 1, was appointed.
Okay,
and
that
he has
case wherein you are Umalata Dole.
No, my lord, I am for Dipti Prasad Pegu.
Okay, you are for Umalata Dole,
Yes, your lordship, the petitioners.
petitioners. So your service from 2007, according to the government,
The impugned order and
impugned
the
order
government.
is not there.
Yeah. Yes, your lordship.
And you approach this court, her
Lordship, I'm the petitioners impugning the
order,
order under section 14 of
14
the act.
order.
Yes, your lordship.
So in that case, an interim order is there by which her provincialization.
Yes, your lordship. There's a
Why
stay
we
of-
hear the interlocutor? We hear the main case. We'll hear the main case.
Yes,
You start off.
Lordship?
Because decision in the interlocutory would be a decision in the main petition. Hope you have no problems hearing of the main case. Will be this.
Meanwhile, there is an order passed by Justice Bujor Bura on 8/9/23.
Huh.
Where he had recorded in the second para, in the circumstance an issue would arise as to whether in a venture school, the resolution itself is the final decision of a termination, or the resolution would be the basis for issuing a formal order of termination. And for that, Mr. Chisti was to obtain the instruction and to produce the records as well.
Okay.
Record and then that.
Yes, who is appearing for the elementary? Secondary? None today. Secondary education? Holiday? Secondary education?
Let me allow to call.
Should I pass an order for that? They should be here when the matter is called up.
Lordship, the record will be important. Because everything depends on that.
But it was never your case in the repetition that you were terminated.
Lordship, it is my case that I'm still continuing and I have never been terminated. I have never been given a show cause notice. Lordship, my basic grievance was that I should be considered for recommendation for provincialization. What they were doing typically was they were recommending persons junior to me. So I've come to this court several times before this writ petition. On the ground that, Lordship, I'll show you the documents, that R7, R8, R9, and R10 have been appointed after me and are juniors.
What was your subject?
Lordship?
What was your subject?
Subject, yes, subject. Oh. Arts.
Arts.
Yeah.
Arts teacher. How many arts teachers? You are the senior most arts teacher.
Lordship, at the moment, my instructions are 3 have been left vacant in the provincialization.
Yes, Mr.
Yes, sir.
Mr. Kaushik. The records were called. There is no point in listening, hearing the I. We'll have to go into the main case itself. So on 8/9 itself, the records were called for.
I've been told that SMT system is, Mr. Sisti has the record.
He has it. Where is he?
Well, I'm trying to follow him.
We'll have it after some time. And Madam Chaudhary, you also ponder as to whether that question, as to whether termination, if so, how?
Yes, Lord.
Because you also. Just loud thinking. It's a venture school. Hire and fire policy, we cannot say it may not be bad if there is a resolution at all. Because you won't be coming within the purview of that non-governmental thing. So to what extent an action at that point of time this court can look into?
I'll
Kindly
satisfy
address
your-
on that.
I'll satisfy.
Order no step item 15.
Yes, Mr. Rath.
It was hired on 25th to an extent. The question arises if the MA degree obtained by Nagaland Open University is valid for considering me for the post of headmaster at that point of time when we filed the writ petition.
I heard the matter last occasion.
Lordship. Then the Lordship, it is fallen from your Lordship that did I obtain any permission to go for the degree, that is Annexure 1 that we are obtained with permission. That is a question on last occasion, Lordship. First thing. And second thing is, if the university was valid at that point of time, it was recognized by UGC. That matter has also been settled by an order of this Honorable Court passing a writ appeal, Lordship. I'll give.
At the time when you obtained this degree, you were working
Yes, Lordship.
where?
In the same school, Lordship.
Same school.
Yes.
Where is that application? Where is that
Annexure 1, page 22, Lordship.
application granting you leave?
That is page 22, Lordship.
It was a venture school,
No, Lordship.
Hmm?
No, it was not a venture school, Lordship.
not a venture school. Okay. How did you go to Nagaland daily from Bezara?
No, it was a distance learning education.
Distance
I
learning is
only
not
appeared in
permitted.
Nagaland.
Show me the law, show me the decision that Nagaland Open University may be, Global Open University may be a valid university, recognized university. Show me that they had the authority to conduct this distance learning course. When did you go? 12.
We took permission in 12, took admission in 2013. I've only appeared in Nagaland, Lordship. Other study materials,
Got it.
Lordship.
How? How? What is this decision?
That only validates the
University. No
University.
issue on that. Show me that it had the power to go beyond its jurisdiction. Just show me that.
if Lordship may fix any other. because
No. Today I
my-
fixed it
my
for that. I
name
think I remember now. I asked you from Bezara, you were going daily to Nagaland and coming back.
Lordship, on that.
Private flight. I think I asked you this question.
Mr. S. Hazarika, appeared. My name doesn't show in the cause
Okay.
list, Lordship.
I think I asked Mr.
The
Hazarika.
cause list, my name doesn't show, Lordship. Any other, maybe day after tomorrow will also.
You are appearing for?
Lordship, I am for respondent 6. Earlier litigation, she is the main party, but now one Mazdur Ali is the in charge. Therefore, I am not necessary party.
Lordship may fix on Thursday, Lordship. We'll address on that point.
Today.
At 2,
That much I can give you.
yes, Lordship.
2, I may have to pass 2 orders.
Lordship, after that.
If even required, before that we'll pass, we'll take up your matter. Only satisfy me on the thing that it had the power to offer a course beyond its
Beyond Nagaland
jurisdiction.
University.
That's all.
At 2 o'clock.
Dutta মানে judgment কি তা দিয়ে আছে। Mati. Mr. Raman, we'll take up your matter. Mr. Monta.
Item 20.
Hello,
I'm sorry, I have not been able to go through these briefs, 20 to
it has come
26.
after
By
very- come after a very long time.
this briefs were not sent yesterday.
My lord, I have.
What is your issue?
I have requested my learned senior friend, my lord. I was not aware that my senior friend appears, my lord. I pray for some accommodation, my lord, next week. It has come after a very long time, my lord.
No, what is
Well,
the,
the
what is
matter pertains my PhD degree. After the entire process was done, it was cancelled by the university authorities, my lord. And that is on the basis of a complaint filed by my own guy, who had earlier given a certificate
that you have done
my
it?
thesis is all right and there was a decision by the executive council, my lords, that I should be sent to appear before the Viva Voce, which is the last step. And thereafter, after the EC's decision, by forming a committee consisting of 3 persons,
Mr. Rama, you are appearing for whom?
I am representing
the private respondent, my lord.
private respondent 6.
You are the guide.
Yes.
Okay.
So my question is, legal question is whether the High Court can offer a PhD degree.
We cannot.
That is the case. That is the case.
I'm not trained for that.
But we can look into whether he was discriminated against.
That is true.
Only
But
to that
he-
extent.
But here,
Whether he gets a degree
so
or whether he gets a PhD degree or MPhil degree or he doesn't get a degree, that is for Mr. Fukan to look into.
that court cannot.
No, but
Under 226 court cannot
if
interfere
we
with the
find,
subject.
if we find that there is a procedure for
Yes.
acquiring that
I am
degree,
following the
and
procedure.
in that procedure, he has been discriminated, we will surely come.
That university you can say, but as per I am a research guide. So under my guidance,
Mr. Roman, if you have in the guidance while doing, discharging your duties as or a guide, discharging your guidance, if I may call it, as a guide, and you had acted strictly with the norms, his allegations will be held to be invalid. But if you had acted in violation of some norms,
In violation of the guidelines or
norms, then we will have to come in because we'll have to protect her.
lots.
When it's
Any
convenient.
day convenient for mine.
15 February.
15th, that week you leave it. It's too congested. Many matters are fixed. You can have it from 19th any day.
Perhaps on a hearing day, my lord, if it's on any day, my lord. After 19.
28th,
28.
on the prayer of Mr. P. Monto, Learned Counsel for the petitioner, not objected to by Mr. H. Rahman, Learned Senior Counsel appearing for the respondent number 6, and Mr. P.J. Fukan, Learned Standing Counsel, Guwahati University, list this matter again for admission hearing on 28/2/2024.
Deeply obliged.
That day we will try. You just first take us through the
Regulations, my lord.
norms and then show what, because whether you get a degree or not, that's
That-
none
I'm not praying
of
for
our
that.
outlook.
Deeply obliged.
For admission item 16. Lordship, hearing this matter, the meeting which was supposed to be held on 22nd of January was cancelled due to Lordship, the Ram Mandir, there was a holiday, Lordship. So the
Okay.
meeting will be held, Lordship, very shortly, Lordship. So
Okay.
I may be allowed 3 weeks time.
Mr. D. Upamanyu, in terms of the earlier orders passed by this court, has submitted that the meeting said that the decision as required to be taken in the matter by the respondent authorities could not be taken as the requisite meeting could not be convened after last day,
22nd January.
after 22nd, 22/1/2024. Post office submits that the said meeting would be convened and a decision as required. A decision on the issue involved, on the issue involved in the proceeding shall be taken. Full stop. Mr. D. Upamanyu submits that the meeting would be convened shortly and the outcome thereof shall be placed before this court. Also, accordingly, list this matter again on. We'll give you some time, but this time do it.
Yes, Lordship.
6/3/2024.
Highly obliged. 6-3.
Items 17 and 18.
Lordship.
Yes.
Yes, my lordship.
What happened?
My lord, had asked me to obtain the instruction whether the signature is his or not. So the signature is his. So my lord, I would like to take you to page number
Records.
31 once, my lord. Page 31. Page number 31. my lord.
Records are here.
Yeah, records are here. Page number 31, my lord, once. My lord may see, this is an order by the Joint Secretary and Director of Secondary Education, my lord.
When was the selection?
Selection was 3/1/2019. That is at page number 36, Annexure 7A.
Okay, we'll first, let's go to
833 of the repetition. The record, my lord.
So, may I submit, my lord?
I've marked the.
the selection is which date? You again told.
3/1/2019. Page 36.
I have flagged 2 issues, Your Lordship.
Flag mark.
Since your
I have pink flag mark, my lord. The
Pink
ACR
flag
of the- Yes, ACR of the petitioner. Which he submitted before the selection committee. Does not tally with page 33 of the petition. Found the pink flag mark. I've written there ACR of petitioner, my lord, flag.
ACR, yes.
ACR of petitioner. Here there is no signature of the receiving officer and the inspector of schools.
Lordship. Lordship, may I submit, your Lordship?
Hmm.
There are two issues here, your Lordship.
Hmm.
First, relating to my ACR, which was the original case they have, your Lordship,
Hmm.
that my ACRs are not in original, your Lordship. Now, second issue is, your Lordship, the marks awarded to the petitioner, respondent number 6, your Lordship. Now, so far as the ACR is concerned, your Lordship, initial.
You are Gangadhar Burma.
Gangadhar.
One second, one
Lordship.
second, one second, one second. Mr. Kaushik, his records are all pertaining to that selection.
Actually,
Huh? Sure.
yes.
These records are here. These affidavits that he has, the page 33, 34, it's available.
The selection committee.
I don't know, in your records, it's available. Same document.
My lord, that is where I was coming to, my lord.
I'll come to you.
Pursuant to this order. At page
Page 29.
29, yes.
29 is the letter and page 31 is the order, typed copy.
Let me submit, your Lordship.
It will.
I will clear your Lordship everything. What has happened, your Lordship?
Okay.
Actual part. What has happened, your Lordship? Selection was conducted on 3-1, your Lordship. Now, so far as the ACRs are concerned, your Lordship, ACRs are not submitted by the petitioner, your Lordship. That your Lordship will kindly note. The first thing. ACRs are, your Lordship, in seal cover. It was submitted to the selection committee by the principal, your Lordship.
How do you establish that?
Your Lordship, that's, they can verify it, your Lordship, because your Lordship, that's, how can I get the ACR, your Lordship? It is confidential record, your Lordship. That's the procedure, your Lordship. And I am not the custodian under the rules, your Lordship.
Okay, Mr. Vatagut, selection is on
3-1-2019.
You all appear.
We all appear, your Lordship.
Mr. Just find out the minutes and the documents of 3-1 specifically. Of both petitioner and the private respondent.
Now, your Lordship will kindly come to page 36.
Jayanta Kumar Burman, I suppose, private respondent.
Private respondent, Jayanta Kumar.
Yes. Page?
Page 36 is the comparative statement, your Lordship. Now, here, your Lordship, in column 10, your Lordship will find that I was not awarded any mark in.
Okay. Where did you get this annexure 7A?
Lordship, I will. So,
No, I asked you. There's a reason why I'm asking you.
Lordship, I will come to that, your Lordship. Now, your Lordship, when this has happened, your Lordship, I was not awarded the marks, your Lordship. I filed a petition before the director, your Lordship, who is the member secretary of the state level selection committee. Then, your Lordship, what has happened? Your Lordship will kindly come to page 31. That probably they wanted to show. In respect of Gangadhar Burman, 80 Solmara so-and-so, he is requested kindly, this is the so-and-so, ACR for the year 2017-80, duly signed by the principal of the school in which he was working, duly countersigned by the IS Nalbari. In respect of so-and-so, then the member secretary, the Rajeshwar Mujumdar, your Lordship. The school selection committee, Belshore HS School, will take necessary steps for obtaining the above documents from the aforesaid members and submit the same to DSC Assam within 7 days. This has reference on the hearing held on so-and-so, the conference hall of DS. Now, your Lordship, this document, your Lordship, which is in Annexure 6 and 7, this was submitted by the member secretary to the. That's why your Lordship will kindly come to the date, your Lordship.
26-2. Now it's clear.
And then 6-2, your Lordship. Then it is after your Lordship, selection was conducted, your Lordship. Now they submitted it to the authorities, your Lordship. Now after this, they received it, your Lordship. Then they passed this order, your Lordship. Your Lordship will kindly come to order that 611, page 43, your lordship.
High Court order.
Not High Court order, your lordship. No, your lordship. 611. That is High Court order, your lordship. Prior to that, your lordship, there was an order.
Order appointing joint of
Lordship, 29, 2019. 29, page 41, your lordship. After receipt of everything, your lordship, now they have, your lordship, passed this order initially, which I subsequently put to challenge. On verification of reveals that Gangadhar Burman passed B.Ed degree twice, that is the ground. Firstly, he passed B.Ed in the year 2011 from Singhania. Secondly, during so-and-so passed from Guwahati University. Moreover, for the year 2017-18, there are two different set of ACR recorded and signed in the name of Gangadhar Burman. It is not acceptable in the eyes of law. Now, your lordship, it is the authority of inspector of school and principal who will prepare the this ACR, your lordship. It was, your lordship, as I have shown, your lordship, through the respondent number 5, it was brought by the
We are considering the writ petition, okay?
lordship.
We are considering the writ petition itself.
Lordship. Now, your lordship, if there are two sets, how can I be blamed for that, your lordship? And your lordship will kindly come to this page 36. There is no allegations that I have tampered with this. There, para 36. The remark column, your lordship. He does not submit the BSc pass mark sheet and ACS are not found in original.
So this
That's
was
the
on
only-
3-1.
There, and
Then the direction from the joint state level selection,
they have sent it, your lordship.
21.
21.
26, again, the respondent number 7 receives this.
Now your lordship will kindly see. Therefore, your lordship, when they have passed the last order, your lordship, there is no mention anything about the ACRs, your lordship. ACR has not, issue has not been considered. And the Rajeshwar Sharma, your lordship, respondent number 5, your lordship, in his affidavit, what he has stated, your lordship.
I think last time we went.
Lordship. Categorically, he has stated, he has never said that ACRs are not there.
Yes,
He
that's
has
true.
categorically stated that
That
the
page
relevant
67.
documents, including ACRs of all candidates, were duly considered.
I pointed this out.
Lordship.
Page, para that 3. Yes.
Now, even in the final order, they have not referred to the ACRs, your lordship. That means that issue has gone. But your lordship,
Gone, not gone, but anyway, from where did you get this page 36?
lordship, this is your lordship 36. Subsequently, when this was your lordship, since this has not been disputed, I have not made any
No,
statement.
from where? From
Lordship, from the authorities, your lordship, in the government, your lordship, I have, your lordship, collected it, your lordship.
any statement to that?
No, because your lordship, no one has disputed, your lordship, and no
No,
one,
not on that. The original there
lordship,
is somewhat something different.
lordship. Because the original, your lordship, the original one, your lordship, there are three, ultimately there are 3 ACRs so far as I am concerned.
Not the ACR, not in the ACR, Mr. I'm on the page 36, Annexure 7A, statement of interview of
Page, your lordship,
page 36.
that I have collected from the, because your lordship, no one has disputed this, your lordship.
Whether does it?
If necessary, I will file an affidavit to
No
that,
need.
lordship.
Just.
No
Yes,
one
you
has-
got it, Mr.
And finally, your lordship, I just wanted to point out the biasness shown by the selection committee. I did not plead, your lordship, because your lordship, both the affidavit for the private respondent as well as the selection committee was filed through one advocate, your lordship. That itself, your lordship, we can, your lordship, smell mala fide from that
That's
itself,
okay.
your lordship. The independence.
And for 2 days' work, he was given
Yes, your lord, 2 marks, your lordship.
marks.
This is palpable, your lordship. Illegality
And
committed.
in the marking, if you can come, what is the further argument you have to make with regard to the, because you were not marked for ACR,
Lordship,
right?
lordship,
So you are entitled to at least 1 mark for ACR.
lordship,
Hmm?
lordship.
So your score becomes 70.
Lordship. And if
And if this 2 marks is required, it becomes
6
down. Okay.
And your lordship will kindly see why I have put this order, which was copy was not with me, your lordship, in the second writ petition. The final order passed by the authorities, which was not communicated to me at any point of time. Your lordship, last page, your lordship. Page
Writ petition.
36, writ petition, your lordship. 66004. The order has been passed in such a manner, your lordship, ultimately, even if I have to participate in this subsequent selection, your lordship, this order will always staring at my face, your lordship. This will be a bar for me, your lordship. Because for all times to come, they have given a finding, your lordship.
You mean that 29, 2019?
Lordship, 23rd June 2020, your lordship. 23rd June 2020, that is writ petition 6004 of 2022. Page, your lordship, 36, last.
6004.
That, your lordship, I have obtained subsequently, your lordship, through RTI.
Yes, Mr. Kaushik, anything you get? Towards the end, you will find the
Yes.
same set of
Same
ACRs.
That is after the hearing, he has submitted this.
Huh?
After a hearing that was conducted pursuant to that order.
But that matches with that page 33 and 34.
Because the forwarding letter.
Where is your that? Are you there?
Page 36, your lordship. Last page, your lordship, of the petition.
This is that CMJ.
Lordship. They have, if however, since so and so, so and so, so and so. Ultimately, your
Well, this is if you have a degree, other degree, we'll not,
Lordship.
we'll interfere with this. We'll say that if you have a degree from Gautam University, well and good.
This is my case, your lordship.
Yes, Mr. Sharma.
Yes, my lord. My lord, may I?
Yes, now it's your.
Yes.
Open
My lord, on
to you.
21st February 2019, there was I would like to read out that order to you, my lord. In respect of Gangadhar Burman, Nalbari, he requested kindly to provide a copy of ACR of 1718 signed by the principal of the school in which he was working and duly
Who
countersigned.
has written this?
This is page 31. This is by the order of the DSC. Page 31, my lord.
2776.
Yes, yes, my lord, 2776. So my lord may see, in respect of Gangadhar Burman, he is requested to kindly provide a copy of the ACR for the year 1718 duly signed by the principal of the school in which he was working and countersigned by the inspector Nalbari. And then the position was said that the member secretary school committee, Belsor High School, will take necessary steps for obtaining the above documents from the aforesaid members and submit the same to DSC within 7 days. This is a reference to a hearing held on 19/12/2019 in conference hall of DSC Assam.
Okay.
So my lord, the date is 21st Feb 2019. Now my lord may see the inspector of school signature is of 6/2019. So how did the petitioner here came predicted that an order is going to be passed, that and an inspector of school will sign on 6/2019? Rajeshwar Majumdar was not a verifying authority. He was just asked to receive it and send it. So how does the signature of 6/2019 came in here?
Okay.
That means there was a pre-predicted. So he has not come with clean hands. Because an inspector of school signing before an order being passed, how can that ACR be accepted? So my lord, thereafter, my lord may see in the selection committee, at the my lord, before
There is a reason for that.
reason for what, my lord?
For this, maybe it was subsequently signed by the inspector of schools. Because in the office, there's records.
It's the
There
same order,
is-
my lord.
No. There is a ACR of Jiten Burman.
That the second one, subsequent one, your lordship.
Your original handwriting. Wait.
In the last full of green flag mark, I have flagged it as application submitted after hearing.
Yes. ACR of the petitioner. And Jiten Burman. And the original of that. We have one where only Jiten Burman's signature is there.
Yes,
Okay.
my lord.
And then we have another one. Mr. Kaushik has marked it here. After the hearing.
Yes.
So here we find that Jiten Burman, same.
Yes, madam.
Both are same.
Yes.
Here, only thing, the inspector of schools has signed it on 6/2, maybe. When was the hearing?
Hearing was on 19/2.
19/2.
So how can
Maybe.
people
When
be
was
saying-
the letter for that hearing issue?
Letter was 4/2.
4/2.
Yes.
Say maybe
My lord.
this was, no. This happens. It's not that it will not happen. This inspector's signature, because what he produced at the first stage matches with the,
Yes, my lord, I'm not, my lord.
because this good work that was there, it was not there in the one he submitted. It came subsequently.
My lord,
Now let us see page 33 for a minute.
My lord, may I just submit my case once, my lord?
Yes.
Yes. My lord.
Now you will also have to meet. You are appearing for two parties.
Yes, my lord.
The interested candidate also. How can you?
No, my lord, you Sharma was appearing, my lord.
No, you have filed the affidavit of both.
No.
He has filed.
Respond, you are appearing for whom?
For respondent number 5, for Rajeshwar Mazumdar, my lord.
Page 70, your lordship, the affidavit of respondent number 6 through.
So
SP
this
sir.
is, this page 33 immaterial, because this is something which was there, got after the inquiry.
Yes, my lord, may I just submit here, my lord? My lord, what has happened, that when the selection happened, my lord may see the page where it has been reflected. At page 36. That he does not submitted the BSc mark sheet, ACR are not found in original. That is why the marks were not given. So, my lord, the entire point was that the ACRs were not submitted in original. Therefore, thereafter, he gave a petition saying that an inquiry should happen and the fresh ACRs were called for. My lord. Accordingly, on 26/2, fresh ACRs were provided. Now, my lord may see.
How many marks was it Jayanta Burman given for that ACR?
Lordship, he was given your lordship 2 marks.
2 marks. Okay. Go
He
ahead.
is also good, your lordship.
So, my lord, now, my lord may see that at the order. At page 41. Moreover, for the year 2017, there are 2 different sets of ACR. So, my lord, that means it has been accepted that there were 2 different sets of ACR by the DSC. That means the ACR which was submitted before the selection committee and the ACR which was submitted, they were not same. And that my lord has rightly pointed out right here that even the ACR which was not submitted in original and the ACR which was submitted were 2 different sets. And because of that, my lord, the marks were not given to him. And my lord, thereafter, there was a writ petition filed. And after the writ petition being filed, my lord, after the writ petition being filed, an order had, at 49, page 49, my lord, that as per the order of the Honorable High Court, you are requested to submit ACR of Sri Gangadhar Burman of your school for the last 2 years in regard of appointment of regular principal of Belsor. The ACR of the employee concerned should be submitted in a sealed cover to the Office of Submission Government in 3 days. This is the second writ petition with regarding to ACR, my lord. So after that, the ACRs of all the 3 persons were sent on 25th Feb to 2020. And my lord, thereafter the appointment. Now, my lord, may look at the additional affidavit filed by them.
Mr. Kaushik, the marking in the ACR is on the basis of that grading by the inspector. And in absence of a grading, what happens? It will not be marked.
And if the last ACR also, my lord will find one difference. In the last ACR which was submitted after the application, down below, my lord, there is a note by the member secretary
which is not there in.
4-3. This is afterwards, even afterwards.
No, not 4-3, my lord, in the last.
No. 4-3-19, President and Secretary SMDC Belsor. Belsor is the school
Yes.
wherein the interview is being held. He's from Solmara. Right? This is second time produced scan copy not accepted, so and so, so and so.
That portion is not there in page 30.
It's not there. Maybe this is, and the signature is also different. 26-2 here,
Yes.
the documents, both different. And there is another one here. Another is here.
Yeah, yes, and there is one.
Yes.
So
how did you mark?
No, my lord, thereafter I'll come to my lord.
No, you come to wherever you.
Yes, my lord. Now, my lord may look into the RTI application, my lord, once.
Sir,
Lords.
here we find there are 3 ACRs. One blank.
Lords.
Blank to the extent that there is no recording of the inspector of schools.
Lords.
We have a set of ACRs here where the inspector of schools has marked Gangadhar Burman on 2/1/19 as good.
Lords.
Right? And this continues for the relevant years. Now we have another scan copy wherein, which is there in page 33 and 34. It is 6/2/19. Why? These 2 markings.
Lordship, that I can't.
You can't tell.
Your lordship will kindly for that, your lordship will find rule 3 of the Assam Services Confidential Rule, your lordship. It's very clear. Maintenance and custody of the confidential role. The confidential role in respect of an employee shall be maintained in the safe custody by the respective controlling officer, head of the office in which the employee holds the substantive appointment, your lordship.
You check up the ACR of the private respondent.
It is there.
I know that. Just check it up. Whether it can be marked. Got it?
Yes.
No? How marks were given for that? If the ACRs are problematic, if there is no problem, then both will not get marks. However, you marked, Mr. Sham. You means your.
I have not, like the ACR which was submitted, I don't have the record of it. So
The
I may-
records are there. There is no marking. No grading. Okay, what we do is, we will reduce your 2 marks
my
and your
lord.
2 marks for your experience as headmaster.
No, my lord,
2
that is-
days you can't get 2 marks.
No, my lord, I can get 1 mark.
We will remand back the matter. Let the government.
No, my lord.
Why should we waste our time here?
No, my lord, I have.
We will clarify those issues and send it
Yes,
back.
my lord, but the selection committee, I still deserve 1 mark. My lord may see
Okay,
that.
we will give you 1 more mark.
No, my lord may see it here.
Without even asking what it is, I'll give you 2 marks. Take away 4 marks from you
No,
and
my
give
lord.
you 1 mark.
No, my lord may see here, the ACR grading which has been done, it has not been wrongly done. My lord,
There is no grading, Mr. Sharma.
no, my lord, may I just submit here, my lord. My lord may go to the additional affidavit which was filed by them.
Hmm.
This is after the government's order, the High Court's order.
Okay.
My lord may see to it, my lord.
Additional affidavit. Okay.
P61.
I have it with me.
This was after the High Court order that you call up the ACR and then you select.
I know
the-
that.
Yes, my lord.
I have seen it. That's why. But in the record, this is not there.
My lord, this has to, my lord may see this ACR of this ACR which you given to RTI, received through RTI, and the one which has been received, one which has been there, are both different because the fresh ACR has been given.
Okay. This is your argument?
No, my lord, may I submit
Is
here?
this your argument,
No,
Mr. Sharma?
no, ma'am.
Finalize your argument.
No, yes.
Don't waver.
No, I'm not,
Finalize.
I'm not waiving here, my lord.
Page 62 is the ACR, right?
Yes, it's page 60.
Okay.
My lord,
Done.
no, my lord, may I see?
We are proceeding. Now we have, now everything is very clear.
Yes, my lord. See the
See
copy.
the date.
Yes, my lord, this is 24/2.
Huh?
So, my lord, may I just submit here, my lord? Let me submit once, my lord. This ACR was won after the judgment of the Honorable High Court, that you give express ACR. That is why I was showing you the letter, my lord.
I got it, Mr. Sharma, I
Yes.
got it. On the date when this election took place, 3/1/2019.
18, that ACR and this ACR is not the same.
1 second. This part, good. 24 to 2020 was not there.
Not there.
So that means there was no grading there.
My lord, that cannot, yes, my lord.
No grading there.
There.
No marks could have been awarded. Why was the marks awarded? 2 marks. Where his ACR, subsequently that came on record, you are disputing.
My lord.
Now your ACR, it's also not
No, my
on the
lord.
clear.
My lord, may just put, I may not able to put it, let me try again, my lord, once again. My lord, the first thing was that on 12th Feb 2020, when the ACRs were called for, my lord, when the ACRs were called again by the government, the ACRs of the employee concerned should be submitted in a sealed cover to the office in the government in 3 days. This is on 12th Feb 2020. Thereafter, my lord may see the name of the impaneled candidate of Belso High School are as follows. This is 25th Feb 2020.
Okay.
Thereafter,
Why was this called for then?
this was called for by the Honorable High Court's order. Honorable High Court's order has been there at page 46. It's his writ petition. Having heard at page 46, my lord. Having heard the learned counsel for the parties and also having perused the material on record, the court, it will be appropriate for the approach raising so that the issue related is found to be valid. The state authority will review the recommendation made by the school and pass up in while doing so. We'll also hear both the petitioner and would stay liberty to submit along with before passing this cell. There are no appointment or shall be issued. The petitioner shall submit his approach within a week by submitting. The authority will do the needful to above after receiving the representation. So ACRs were called for thereafter, my lord.
Who called for?
My lord, the Commissioner and Secretary at page 47.
That is that letter, Mr. Okay.
So ACRs were called for. So my lord may see, as per the order, you are requested to submit copies of ACR.
Now, can the ACR that are being called for
Yes,
be
my lord.
different from what was produced before this election committee?
My lord, the ACRs that were submitted.
Why you? Forget him.
Yes.
I'm not even worried.
Yes.
The ACRs that you submitted before this, you means that respondent number, whoever the selected candidate is.
Yes, my lord.
Submitted before the selection committee.
Yes.
Can a different ACR now come on his behalf before the authorities?
My lord, at the second time when the ACRs were submitted, those ACRs will be different because these were the new directions of the ACR. That whether the statements in the ACRs will be same or not, that has to be looked into, my lord.
No. If the grading is to be seen, he has also the grading now. You also have the grading.
My lord, at the time of the interview, he did not
You
even...
only dispute his ACR because of 6-2.
No, my lord, my lord, I did not have the entire...
No. The ACRs, the remarks, same everywhere.
No, my lord.
change. Jiten Burman signature, same everywhere.
My lord, may I just submit here? My lord, if it is not...
5 more minutes.
Yes, my lord. My lord, the post of, at the time when Jiten Burman, my lord, when Gangadhar Burman submitted his ACR during the selection interview, those ACRs were genuine ACRs by Jointer Burman because there was no remark against the selection committee. My lord may see the record here.
No, I'm not against, I'm not on that.
Yes.
Joint of Burman. You're talking about joint of.
Yes.
Okay.
Yes.
Joint of Burman submitted a ACR?
Yes, yeah.
That is genuine?
Yes. Very good. It has been written, my lord.
No. See, that's what I'm trying to indicate. See.
My lord.
Where the very good is written. Very good is written against a remark. That is not the grading, Mr. Sharma.
Yeah, that is not the grading, my lord.
If that is the grading, show me the law, I'll pass orders.
No, that is not the grading.
Then
so my lord,
how could the selection committee grade you on that? Mark you on that? Mark Joint of Burman on that?
So my lord, even if my marks for ACR is gone, my lord.
Gone. Accepted. Gone.
Okay, my lord, if my marks for ACR is gone,
okay.
Still I have a chance of...
Yes, you have a chance. You have a chance.
My lord,
one second, Mr. Sharma, let me write down. ACR marks to be deducted of Joint of Burman. Okay. That issue Settle. Mr. Sharma, now come to the second issue.
Yes, my lord. The second issue, my lord, may see.
I'm not even going to, I'll only interfere with the impugned order. The further thing is Mr. Kaushik to do.
My lord,
not
at
me.
page 33, my lord.
Come to page 30. No, forget it. ACR, I have given no marks for him.
Yes, my lord, ACR, my lord is trying to reduce my point even in the in charge as principal.
Yes, no,
Yes.
now come to that in charge.
Yes, my lord may see experience is in charge of principal 1 mark for each year of experience subject to the maximum 3 marks.
Hmm.
I was,
No, just a moment. Where is that letter? Where is the,
my lord, page 36.
36. Now come to that. Experience as in charge principal 1 mark.
For each
When
year.
did you join as principal in charge?
My lord, I joined as principal in charge
Page 37.
as 31st December 2018.
When was the selection held?
3/1 2019.
3/1/2019.
Yes,
So is there any law which says that this period should be treated as 1 year?
my lord, it just says as a selection committee, experience as in charge of principal 1 mark for each year.
Each year of
Each year, my lord, it is not written calendar year. The word calendar is not there.
year is there 365 days?
No, each year is written, my lord.
Each year,
Yes,
65 days.
so even on 2018.
So that is your submission.
So my, and 2000,
There is a judgment against you, Mr. Sharma.
no, my lord,
of this court.
I'm submitting it because I was in charge for principal.
So you accept that you were in charge for 2 days before this election?
Yes, that is there on record, my lord. For that, I have to receive a 1 mark.
Okay.
So if I receive 1 mark for that, then each year,
HM in charge. Each year should be read as completion of year. So 31st you are appointed. On 1st you will get 1 mark.
my lord, what I'm submitting
No,
here.
that is the argument.
No, my lord, there were 2 marks given. Even if my lord remove 2 marks, remove 1 mark,
No, how will I remove?
No,
Give you
even-
1 mark.
because being an in charge at the time when the interview has been conducted, I am eligible for 1 mark.
Show me.
Yes, my lord, experience is in charge, principal 1 mark for each year.
Each year you give a meaning. Each year means are we that should we be so oblivious of the fact that we can't understand a word year?
No, obviously, my lord, the year.
Or you don't understand that
No, my
word
lord,
year?
year stipulates 365 days.
Huh.
So, my lord, but if the selection committee at the moment and the
No,
understanding.
if 365 is not complete, how can the selection committee give him that mark? Show me the law. Show me the law on that. That even if 1 day prior to the selection a man is appointed, he'll get 1 mark. Fine, I'll lay down. Because it will be applicable across the board. Show me that law.
No, my lord, in that case, I have to go through my, because it's not written each calendar year, it's written each year. So each year can also stipulate the year in which he has been functioning.
Show me that law.
My lord, for that I have to
You have it at 2 o'clock. You get that law.
my lord, I would not like to have to go to that argument at all. Because
Get me.
Because as of my 01, I'm applicable for at least 1 mark, being in charge at the time of the selection committee. That is my only argument.
Mr. Sharma, in spite of that prescription, if you can show me that this has to be read as 1 year, I'll do it. Yes, Mr. Motago. If we can show, it'll help others also.
If possibly, my lord, the ACR, that is of the phone number 6.
Hmm.
He got 2 marks marked because of page 27 of the debt office member.
Hmm?
Office memorandum, page 27 of the report. This is the guidelines how the marks has to be allotted in this election. And your lordship will find.
There is no grading, mister.
No. Your lordship will find
Okay.
how the marks will be.
Hmm.
Good 1, very good and above 2.
Hmm.
2 marks is the maximum marks.
Hmm.
Now, if your lordship find the ACR of the private.
No. Those are against remarks.
Yes.
That is not the final grading, mister. Grading is good.
Yes.
Finally, in 24/2/2019, when his ACR was graded, it was good. So there is no grading of the inspector of schools there. So no marks. Okay, fine. Either parties, if you want to give a note by Thursday. We are listing this matter on Monday for delivery of orders. List this matter again. List this heard the parties are playing. Party number. That's what happened for the respondent number for the petitioner.
Nine.
Mr. S.P. Sharma, you are for respondent number 5.
Yes, and you Sharma for respondent.
U Sharma is not here.
My lord,
You are not permitted by virtue of that relation to argue
no, my lord.
for her also. No, this court will not permit. I.S. Sharma for respondent number 5. Mr. B. Kaushik, standing counsel, secondary education department, for the respondents in the secondary education department. Heard the matter at length. List again on 12/2/2024 for delivery of orders. Records, you keep it. Just give it to me in the morning. I'll fix it at 2 p.m. At 2 p.m. If you get something 5 minutes before that, you have satisfied me.
My lord.
And the notes should come by Thursday. Thursday or Friday, no problem.
Lords.
Done.
Item 19.
May I please, your lordship?
Yes. Yes.
Your lordship, the respondent number 6 and 7, they have filed an interlocutory application for vacation of the stay order, which was passed on 24/8/2021. Your lordship may very well peruse that order, your lordship. May I just read from para 9, your lordship, the order?
9. Yes.
The Act of 2017 is silent to that extent as to whether any precedence is to be given to a teacher of the language, which is the medium of the school concerned. Again, education is a transfer subject under the 6th schedule to the Constitution of India, and under the law of the 6th schedule, the authorities of the Bodoland have a discretion to either adopt the Act of 2017 as it is, or not to adopt it and adopt their own procedure, or to adopt it which modification may be made. It is not known at this stage as to in what manner of the Act of 2017 has been adopted by the BTC authorities and made applicable, as it cannot be said with certainty as to in what manner the Act of 2017 would be applicable to the areas under the BTC, and whether respondent number 6, being a teacher in Boro language, would have any kind of precedence over the other language teachers. We deem it appropriate to provide in the interim that the benefit of the provincialization be not given to the respondent number 6, Narad Chandra Brahma, and the respondent number 7, Lohit Chandra Brahma, until further orders. Lordship, the main issue which revolves around in this writ petition, after filing of the affidavit in opposition by the private respondents, Your Lordship, from the very Dias data, which is the record for the services of the teachers in the concerned venture educational institution, Your Lordship. Your Lordship, both the respondents have taught, Your Lordship, Boro language as the main subject. I have, on the other hand, taught social science and English. And the Act of 2017 came into force in the month of March.
Who were provincialized?
Your Lordship, respondent number 6 and respondent number 7.
Only 2 persons.
Yes, and one Sarveshwar Brahma as a maths and science teacher, Your Lordship.
So one science, R6 is as what?
Your Lordship, perhaps, Your Lordship, it has not been made clear, but I state that he has been provincialized as a social science teacher, and the respondent number 7, Your Lordship, Your Lordship, I state that the respondent number 6 has been provincialized as the language teacher.
Respondent number 6 is Lohit Chandra Burman.
No, Your Lordship,
Narad Chandra Burman.
Yes, Your Lordship. And respondent number 7 as a social science teacher, Your Lordship.
Where are the DSC minutes?
The minutes of the
District Scrutiny Committee.
Your Lordship, the Elementary Education Department, they had filed an affidavit.
Yes, director.
Yes, the director, Your Lordship. But, Your Lordship, in that particular, they did not specify the minutes of the meeting, Your Lordship.
No, that's not on record.
Yes, it is not on record, Your Lordship.
You have it with you. DSC minutes.
Elementary education, your lordship, they have to appear, your lordship.
No, I'm not on that. The district
DSC,
school, DSC
I
minutes.
don't have your lordship.
Why? So that will clear as to under what, against which post the persons were recommended. If they were recommended against
Nothing.
social studies and he is
No, your
senior,
lordship, I have stated that the language matter, your lordship, I have stated in our affidavit, your lordship.
yes,
That
page
is on paragraph 5 of page 180. 180, running page, your lordship.
Okay.
Paragraph 5.
Hmm.
That as regards to the statements made in paragraph so and so, the answering deponent begs to state that the petitioner was appointed.
Just a moment. Mr. This is item number?
19.
Mr. Deca, give me your date of joining.
Yes, your lordship. I joined on 1/1/1993 at 10:15 AM. your
Okay.
lordship. I'll just take your lordship.
SS and English, no?
Yes.
And the private respondents?
Yes, your lordship. The private respondent number 6 had joined on 1/1/1993 at 10:25 AM. And respondent number 7, he had joined on 1/1/1993 at 10:30 AM.
Okay, both of you joined on the same day.
All of them had joined on the same.
Same day. Who is by virtue of age senior to you?
Respondent 7.
7.
Lohit Chandra Brahma,
Headmaster.
Senior.
who is the headmaster of the said school, your lordship.
He was not provincialized as headmaster.
Headmaster, your
He's
provincialized.
provincialized as
Yes,
headmaster.
your lordship. And by age.
Where is
your-
the provincialization order? Yes, Mr. Deca, where is the provincialization order?
Yes, your lordship. I'll just take your lordship to page number 83 of the affidavit in opposition filed by respondent number 7. Your lordship, page 83. Not your the running page of that affidavit in opposition, your lordship. I'll just take your lordship.
Give me that. Filed by?
File
Respondent number 6.
respondent number 7, your lordship.
We'll require the DSC minutes.
Yes, your lordship.
That will only give clarity.
125, your lordship, page number.
That can be provided by elementary education, your lordship.
No, DSC is with you there.
Yes, your lordship.
Either of you, on the next date fixed, the standing council, PTC, and
IA is going to be vacated.
we will see. The standing council, PTC, Learned Standing Council, PTC,
Yeah.
as well as the Learned Standing Council Elementary Education Department shall place before the school the minutes of the jurisdictional DSC District Scrutiny Committee's meeting, wherein the cases of the petitioner and the private respondents were considered. Also, list this matter again on 4/3/2024 for further consideration. 4/3/2024. On that day you produce, because without that, we cannot ascertain which post who was recommended.
Yes.
But he is misleading actually,
Yes, your
because
lordship. We had. filed
one
our
is social
affidavit
studies
thoroughly,
teacher.
your lordship.
and another is language.
Yes, your
But
lordship.
the headmaster is language teacher. And respondent number 7.
We'll see, just get that. We'll
6 is
we'll
language
vacate it.
teacher.
I'm not going for the IA. We'll finish up the
As
repetition.
per dice code also.
Yes.
Item 21.
Much
Deeply
obliged.
obliged.
Yes, Mr. Golden. Yes.
May I please, your lordship, my
Mm.
lord. Matters pertaining to the provincialization of service of teachers, my lord.
Mm.
My lord, in this case, my lord, the petitioner was the headmaster, my lord, head teacher, my lord.
Mm.
And respondent number 6 and 7 were assistant teachers of
Mm.
Bapuji MEA school, my lord.
Mm.
My lord, after 2017, Act came into force, my lord. The district, Dhubri district recommended the name of the eligible teachers, my lord,
Mm.
to the director, my lord, to the state scrutiny committee, my lord. but state scrutiny committee having noticed some anomalies, my lord,
Hmm.
directed to re-verify, my lord, and submit authentic proposal, my lord.
Hmm.
In earlier recommendation, my lord, the name of the petitioner was not recommended, my lord.
Hmm.
After re-verification, my lord,
Your
lord-
name came to be recommended.
Yes, my lord. Your lordship will find case 24,
Hmm.
25, my lord.
Hmm.
Sorry, my lord.
And now who has been provincialized?
Now, my lord, 6 and 7, my lord.
Hasan Ali
Yes, my lord.
and
But Hasan Ali and
Ashrafuz Zaman.
yes, my lord. My lord, in second recommendation, my lord, the name of the petitioner respondent.
What is your date of joining?
Date of joining, my lord? 3/11/1998.
3/11/1998. And that of Ashrafuz Zaman?
Ashraf, my lord, 18/6/2007, and 7 is 25/4/2007,
18/6/2007.
my lord,
And Ashan?
25/4/2002, my lord.
You were initially appointed as a headmaster,
Yes, my lord.
right? Action is correct. What is the mistake? The strength is less than 100, so your post cannot be.
No, my lord. My lord, though I was a headmaster, my lord.
Prove it. Go to the election education tribunal, prove it that you were, in spite of being a headmaster, you were teaching other subjects.
My lord, your
Because he
lordship-
will say, you did not even come out of the room, they were taking classes.
No, my
How
lord.
will this court decide?
Kindly see, my lord, a dice data code, my lord.
Dice
Yeah.
data code is
There is-
again prepared by you. Data is supplied by you. We find it very difficult to.
My lord, it is reflected, my lord, who is teaching in which subject.
I know that. Is it reflected as headmaster also?
My lord, kindly see.
Yes.
Page 25/26, my lord. 25/26, my lord.
Hmm. What is this?
Teacher.
All subjects.
All subjects, my lord.
Okay, fine.
All are.
What is this all subjects?
All are all subjects, my lord.
Where is the original dice data? Come to the next page. Twenty-six. This is 15/16, right? You are Rafiqul Islam?
Yes, my lord.
Baltari Bapuji?
Yes, my lord.
Rafiqul Islam,
Yes, my lord.
all subjects.
All subjects. Then, my lord.
Lokman Hussain,
Science teacher.
social studies.
Social science, my lord.
Hasan Ali,
All subjects.
all subjects. Abeda Khatun, all subjects. Why? Why like this? Because here, Hasan Ali is all subjects. Why he became science here?
My lord.
Social studies here.
Above Ashrafuz Zaman, all subjects, my lord.
No, I got it.
above
But
Rafiqul
why was Lukman Hussain in page 25
Yes, my lord.
shown as social studies only?
Social studies.
Okay. Yes. What is your submission, Mr. Pulta?
My lord, I have submitted my affidavit, my lord.
Hmm.
In affidavit, I have annexed my appointment letter also. I was respondent number 6 and 7, both were appointed as assistant teacher.
Assistant teacher,
Yes.
not specific.
Yes, my lord, not specific. And my lord, as per rule, my lord.
So if that be so, and his contention that he is also teaching all subjects, he should be provincialized.
No, my lord, I have categorically stated in my affidavit, my lord. He is a headmaster. He is doing his duty as headmaster, my lord. And he was appointed as headmaster.
But
As
he
per
is
his
saying in the
appointment letter.
dice data, his name is shown as all
It is
subjects.
prepared by him, my lord.
You proceed to the education tribunal. Exhibit this. This contest we cannot. I can't go and verify the documents there. Where is the order of the appellate order authority?
My lord, impugned order, my lord. Page 44, my lord.
44.
44, my lord. The ground of rejection is that my name was not recommended earlier, my lord. That recommendation was cancelled by this state scrutiny committee, my lord. That authentic proposal was submitted. In authentic proposal, my name was there, my lord. Now they have rejected me, my lord, considering that my name was not recommended.
Yes,
earlier.
Mr. Kaushik,
My lord.
what to do
That-
in
this
this circumstance?
ground- This ground may not be, but page 37, my lord,
Hmm.
is the detailed report of the EO to the
Hmm.
director, my lord, person to
Hmm.
the order of this report.
Hmm.
Here also, my lord, this, the petitioner has been identified as the headmaster.
Hmm.
Now, my lord will find the
Okay. Got it.
column but section 3(1)(11) of the act.
Where,
And in the
what
last,
section?
my lord, he
What
claims that
section?
he is a social studies teacher.
But section so and so, mathematics. Provided so and so, below 100. These activities are not eligible accordingly. Science teacher and two other teachers from to teach social studies and languages. And teachers from are eligible for consideration to sponsor languages. BA headmaster, headmaster, so and so.
The group so constituted, my lord, in the very.
Personally, so and so claims that he teaches social studies. He also claims it. So and so filed before this code 2975
Right.
earlier proceeding.
I know.
Okay. Then that
So
goes
now
up.
they dispute
Hmm?
that who is teaching the social studies, my lord.
That we cannot.
That, yes, sir. That I
Okay.
cannot. And these dice that are also not conclusive. my lord.
No, no. My experience is that it depends on the headmaster.
Yes. And if it is find out that the headmaster, when he has sent it for provincialization, in the particulars, what he has shown himself.
That I'll ask the authorities.
Authorities.
Lordship may also see my affidavit, my lord, page 76, annexure H.
Hmm.
This was issued by the district elementary education officer
Hmm.
to the my lord, director. Pursuant to the order passed by this honorable court in WPC 4115 of 21.
Hmm. This is the second round, Mr. Islam. This is the second round. You had come up before the High Court first once,
Yes, my lord.
and this is the second time.
Second, my lord.
You have come up, no.
Yes, once I have come.
What is your petition?
Premature, my lord. That was
R
Lordship will find that page 65.
R 7 and 6 and 7 both.
No, my lord, say Asan, only Asan.
That means response number 6.
Yes.
When his name was not
At
recommended.
that time, no
second time, my lord.
process was only initiated.
Okay.
Final, there was no finalization.
Same was said to be premature.
Yes.
Okay. Okay. Yes, Mr. Sam, indignant.
Yes, no, my lord. He came before this court, my lord, when his name was not recommended after in authentic proposal, my lord. Then this honorable court disposed of the writ petition asking him to file a representation, my lord. Then representation, he filed representation, hearing took place, my lord. After hearing, all three names were forwarded to the district scrutiny, state scrutiny committee, my lord. Then when there no action was taken, my lord, then this petition,
got it.
filed earlier writ
I
petition, my
got it.
lord.
I got it. I got it. We'll consider. Dispose the headache. File to me. You will have the orders. I'm showing it disposed today, but you will get the orders only on Monday.
Item 22.
Obliged.
Lordship, in this writ petition, Lordship, I have basically 708 degree obtained by the.
Yeah, my lord, some time is required, my lord, for instruction. Actually, our file has been misplaced, my lord.
Yes, Lordship.
We have to
In the
pass-
earlier round of litigation, Lordship, that was filed in 2017. That matter was heard and Lordship it was done CAB. Then thereafter, Lordship, that it was released. The judgment was not delivered. And subsequently, that writ petition was disposed of. And Lordship, the departmental council made a submission that the respondent number 7 has obtained a B.Ed degree in evening shift. And as such, no permission is required. Now, Lordship, I have brought on record, Lordship, all the relevant documents, Lordship, obtained through RTI. Now, Lordship, the Deomono B.Ed college principal has given us the information that there was no any evening shift in Deomono B.Ed college. The class starts at 10:30. And without permission, deputation and leave, Lordship, she has obtained her B.Ed degree. And because of the wrong submission.
When was the B.Ed degree obtained? Which year? Which year?
2016, Lordship. And in respect of another two candidates, Lordship, the department has taken a different view. And in my case, Lordship, they have taken a different view.
No.
Lordship,
I
I am,
also brought on record,
Lordship, I am
Lordship.
appearing for respondent number 7 for the first time, your Lordship.
Was that institution recognized by NCT at that point of time? 16 institution. Very proximate. Have you checked up that?
Recognition, Lordship. Page 35.
Page?
Page 35.
Mr. Just understanding.
Lordship. Page 35, 9. Now, Lordship, the issue here is, Lordship, they have made a false submission that they have obtained her B.Ed degree in the evening shift without hampering the regular classes. And because of that submission, Lordship, my earlier writ petition, although was on different grounds, Lordship, on that count, Lordship, that my earlier writ petition was dismissed.
Who is holding the post now?
He is holding the post.
We'll give him 2 weeks to bring his on.
Lordship, may kindly come to my additional affidavit, Lordship. I have brought on record, Lordship. Page 64. Page
The RTA replies.
RTI reply, Lordship. And Lordship, in two other cases, Lordship, they have taken a different view. Lordship, if without permission, Lordship, they will not be entitled to hold the post.
Have you brought that on record?
Yes.
That page
Lordship.
65.
Yes, page 50 and 51, Lordship. Page 50. And she was my batchmate. This Bonali Saikya Kakoti, Lordship, she was my benchmate in Deomono B.Ed college. The hearing report, Lordship, at page 50. Page 51 is the limit.
Got it. On the prayer of I heard Mr. S.K. Das, learned counsel for the petitioner. On the post of Mr. S. Bhattakur, learned counsel appearing for the respondent number
7, your Lordship.
7. Prays that he be granted 2 weeks time to file, to bring on record his, the effort, to bring on record his stand. Full stop. Also heard Mr. I. Alam for the respondent, for the NCT authorities, and Mr. U. Sharma for the authorities in the secondary education department. List again on 2 weeks. 27.
Lordship, the notice was issued long back, before 1 year, Lordship.
I know that.
Now they have got sufficient time, Lordship, they did not
Fine. We are giving only 26. We are fixing it on 26 to 2024.
Yes.
By which in the event the affidavits of the respondent authorities are not brought on record, the matter will be proceeded basing on the materials available on record. List again on 26. Keep that.
Deeply obliged.
Item 25.
Obliged.
Yes, Mr. Chaudhary.
Lordship, I have signed the affidavit for vetting, Lordship, a 2 weeks time, Lordship.
Weeks time. Mr. P. Chaudhary, learned standing counsel, BTC submits that the affidavit on behalf of the said authorities are ready and would be filed shortly. Accordingly, he prays that the matter be taken up after 2 weeks. Also, list this matter again on 4/3/2024.
Obliged.
Also, it is required that the parties complete their pleadings in the matter and complete their pleadings in the matter before the next returnable date.
Match.
Might key is it? I don't know. I will do top of the. Yeah, I get it. It order to review. It is taking it. Hello? What are you the heck with on Madam Goswami, we'll just finish up the order matters and then come back to you, madam.
For orders item 26.
Yes.
This is regarding, my lord, the updation of scale of pay of the petitioner, my lord. My lord, on last occasion, they are asked to.
Yes, Mr. Sharma.
My lord. Proposal was submitted, my lord.
No, I got it. Yes.
My lord, in this matter, a hearing will be conducted on 13/2/2024. So, my lord.
I'll fix it.
Yes, my lord.
Mr. U. Sharma, Learned Standing Council, Secondary Education Department submits that in terms of the orders passed by this court on 12/1/2024, he has received instructions and it is submitted that the respondent authorities are actively considering the case of the petitioner. And a hearing in this connection is also slated on 13/2/2024. So accordingly, list this matter again on one 1/3/2024, on which date Mr. Sharma shall advise this court as to the outcome of the said hearing.
Item 27. Item 27.
Bravo. This writ petition is filed by the state against an order dated 36/2010 passed by this court in WPC number 2567/2010. So it is seen that নাম দেখাইছেন নাই কেবল Mr. Who is appearing for the elementary here? Not interested.
27.
27, huh?
I'm sorry, my lord, we missed this, my lord. It's just a review of the statement.
On the prayer of Mr. B. Kaushik Bhatikande, list this matter again on 28/2/20. The name of Standing Council, Standing Council, sorry. Standing Council, Elementary Education be reflected for the review petitioner in the cause list.
Grateful, sir. Lovely.
Hemaji.
Hemaji.
Item 28.
Yes, Mr. Kain.
Item 28 and 29 are analogous matter.
Yes.
Item letter 29, my lord. It is a writ petition, my lord. In the writ petition, my lord, I challenge the order of amalgamation between two schools. My lord,
What is the review for?
review vote, my lord, after filing this petition and obtaining the interim order, I came to learn that, my lord, there is an earlier order of this court, my lord, to effectuate that amalgamation order. So I have filed this, my lord, writ petition, and both the matter has been tagged to me.
Okay, you had initially filed the writ petition for stopping the,
Yes, my lord.
and then you come to learn that there is a,
Order
oh,
to effectuate.
withdraw that writ petition,
My lord,
withdraw that writ petition, matter ends.
after that message, there is an order of amalgamation, my lord. Effectuate that order.
Now the amalgamation has been,
No, my lord, there is
What?
an stay order
where?
in my case, my lord. and
In the review,
In the review as well as my writ petition.
you are for?
I have a respondent number 1 and 6, my lord. Motion, this amalgamation was done as per inquiry report dated, my lord.
Where is that
So-
order? Which
Yes.
review of which is you sought for?
Well, firstly, your lordship may kind.
12-10-18.
That is, my lord, at page 45. Sorry, my lord, page 48. Page
No,
48.
High Court order. High Court order,
Yes, my lord. Page 48 in the review petition.
writ petition,
Review.
or review petition. Writ petition. What is the date of the order?
It was, my lord, 12-10-2018.
Okay.
12-10-2000, okay.
And I filed the writ petition, my lord, 8-11-2018.
Okay,
And my lord,
so you say was a wrong order because there was an earlier direction of this court to effectuate that, to
Yes.
get that merger done.
Right.
So you have filed this review petition,
review petition.
right?
Yes, my lord.
A review petition prayer is okay. Now, what is the directions passed in this review petition? Order,
But it was, my lord, 23rd-1-2019. Last time, in the meantime, the interim order dated 12-11-2020 passed in the also shall.
that has been continued.
Yes. So. My submission before lordship, my lord, the school are, my lord, there are, my lord, 2 kilometers distance between the two schools. And my
Okay,
lord, there is a.
if both the matters are to be heard together, we will
Yes,
hear
yes,
it.
yes, that is.
When? Today?
Yes, I am.
Okay. You are ready, miss?
This may be taken next week, madam.
It will not be next week.
Thursday.
It will be a week thereafter.
Madam.
On the prayer of the parties, list this matters again on 22/2/2024.
Item 30.
Lordship, I need judgment officer.
Huh?
Or Supreme Court judgment. My lord.
For this case,
Yes. That is regarding, my lord, the writ petition or review can be taken, my lord, together.
no,
Yeah.
no discussion. अरे किमान मत चलिए थे अपने मामू डाले ना
Paragraph 8.
But
My item number 30 may be take up in the next week, next Wednesday, my lord.
which one?
Item number 30, my lord.
We have reached 30 over. No. 30. Why?
Contempt matter, my lord.
Our Mazumdar is on legs, my lord.
Whole day?
Not for the whole day.
First day? Okay, we'll give you one chance. On the prayer of Miss S. Satya, learned counsel for the petitioners, list this matter again after 2 weeks.
My lord, lordship, I date may fix, my lord.
2 weeks, so no, it will come, don't worry, 2 weeks. On the next day, the learned counsel for the respondent shall place on record the status with regard to compliance of the directions passed by the school. Starting off, wait.
Item 31.
Item 31, yeah, lordship, directed the director admitted to relook the compliance order, lordship. I need some more time, lordship. Next week, any day.
Mr. SMT 60 by referring to the directions as passed by this court-wide order dated 21/12/2023 in the present proceedings praise for being granted another 2 weeks time to take the to place before this court the updated status report in the matter. Accordingly, list this matter again on 11/3 on 13/3/2024.
Item 32.
I'm giving you enough time, Mr.
Yes.
Sushil. Kindly see to that it's done.
My lord, I pray for some more time, my lord, regarding that verification process is complete, my lord.
Oh, that workers, yeah, this is taking a long.
Only one thing, my lord.
Verification process is complete.
Now a decision is.
Now, my lord, with the approval of the vice chancellor, it will be placed in a regular EC meeting.
Okay, fine.
So,
My lord, only one thing, my lord, only small submission, my lord. I have served a notice upon the respondent number 6, my lord. He, despite of receipt of the notice, my lord, he did not bother to represent the case, my lord. That is a
Who is respondent number 6?
That, my lord, lordship
We'll
will
see,
see my affidavit.
we will see, Mr. We'll see.
Yeah.
We'll see, don't worry. Now, Mr. Fukan's endeavor, something is happening. It's a complicated issue, implementation. Let them take it forward. Mr. PJ Fukan submits that the verification process as was undertaken by the Guwahati University authorities is complete. And now the same is being processed for being placed for a decision before the before the executive committee. The regular in charge, it's your headache. For me, it's an executive committee. Any executive committee.
Executive council meeting.
Council, before the executive council for
With the
decision.
approval of the vice chancellor.
Oh, that is yours. Before so and so, full stop. Let's this matter again on 14/3/2024, by which date the decision as taken by the EC be placed before this court. 1 month time, I think is enough for you to hold the EC.
So,
Item
my lord,
33.
regular EC, that regular word should be there, my lord.
I don't understand why it regular. Any ad hoc EC also will do. You have to take a decision. Power is same.
My lord.
Then an ad hoc EC and a regular EC, is there any difference? EC, EC.
All the same.
In your statute, there is no ad hoc and regular. It's
No,
EC
my lord.
only.
Special and regular, my lord.
That's for you to look. And this is a issue where you should have a
They are
very
going to-
special.
We are going to hold a special EC meeting next week, my lord.
Then please,
For holding the convocation, my lord.
place
My lord,
this
so
also.
President of India will.
Place this also. This is also
Lord,
pertaining to lively of people. Place this also.
It will be little bit difficult, my lord.
That's for you to look into, Mr. Pukan. I have passed my orders. You know what to do.
Look, I only pray for that.
I have given you time till 11th. 11/3 March. It's not 11th of this month. 11th of March I have given. I understand.
More than a month.
More than a month I have given you. Hold a meeting within that time.
Since my lord, the agenda is ready in the next meeting, so.
I have
that's why, my
not,
lord,
I have said not the, I have never used the word next. I have said place before EC. Any EC you place,
my lord,
but give me the report by 11.
my lord.
Before 11. 10th, 12 o'clock also if you place, I have no objection. But 11th, I want that report.
Can it be little later, my lord, in the
You
last
want a
week?
little bit more time? Fine, no problem.
My lord, already, my lord, water has already crossed head.
I'll give it to you on 20th. Add one line. 20th. The EC decision should be invariably placed before this court on that check day. Otherwise, orders as may be called for would be passed in the
That was
20th.
Marvelous.
No problem.
most of
Item
it.
33.
Wait, Mr. Lordship. It's a contempt petition, my lord.
Yes,
Our contempt lordship is in court number 1, that is the he was appearing all along. Lord.
he may be in the corridor. Just check up.
No, I have checked, and I
He is
have
not
checked,
there.
and I'm not there. For this case, my lord, I think he has got a is fighting since last
We'll have it
5
at-
years.
Second half. Mr. Sukia, come. With this matter, I will not touch on. You be here.
Item 34.
Get hold of it.
34, we have complied with the order lordship. May I kindly read it? Hey, 34 out of pin video, na? Petitioner was there to file an appeal, and that appeal was disposed of rejecting the claim as a language teacher lordship. That was there.
Enough. Mr. SMT Sisti has
Yes.
produced before me, produced before this court, an order dated 14/9/2023, passed by the Secretary to the Government of Assam, Department of School Education, by which, in terms of the directions, by which the directions passed by this court provide order dated 26/2022 in WPC number 4733/2021 has been complied with, and the case of the petitioner on consideration for provincialization was rejected on the grounds stated then. Also, I perused the order dated so and so, order dated 14/9/2023, and find that the same is in compliance with the directions passed by this court, and accordingly, the contempt petition stands closed. The petitioner is reserved with the liberty to accede the order dated 14/9/2023 before the appropriate forum, if so advised. A copy of the order dated so and so 14/9 is kept on record and marked as X.
I have also submitted to him, lordship.
Okay. Item 35.
See, Mr. So whatever
Yes.
decision is yours.
Yes.
But if this happens in that manner,
Yes, lordship.
this court will also be a bit assuaged.
Yes.
But in every case, if there is a violation, we'll have to come up. Fine, very good.
My lord, in this case, my lord, notice has been issued long back on 10/11, my lord. The question is, my lord, petitioner is aged about 59 years, my lord. So if my lord, may I pray to ask my friend, my lord, to take instruction whether it has been complied.
I will do that when the matter demands that.
Because he is
Pension,
59.
termination, clear-cut violation. These are provincialization issues.
My lord,
Can wait for a day or two. There is no problem.
despite of recommendation.
Take steps last time. If not, next time I'll do that.
My lord.
Seen the office note dated 2/2/2024. The service upon the sole respondent is not complete. Also, in that view of the matter, in the above view of the matter, the petitioner is required to take fresh steps for service of notice upon the sole respondent by way of registered post within 3 days. Steps, registered post with 80, full stop, steps within 3 days. Place this matter after 4 weeks with a report as regards the status of service of notice upon the respondent number 1. I'm sole respondent.
Supplementary cause list for orders item 39.
Here, my lord, we have, in terms of honorable court's order, we have furnished the Dasti service, but she has refused.
Dasti service is no service in contempt.
Then even, my lord, this is not contempt, my lord.
Oh, this is repetition. Oh, she refused.
Refused, and even the track report, my lord, that is also shows that notice has been delivered to her.
In the office note dated 5/2/2024. No, order, in the order of the Lalsima Court dated 5/2/2024. It is held that the service on the respondent number 6 is complete. Also, list this matter for admission hearing after 2 weeks.
May I
Hello,
say
Council.
date, my lord?
Item 40.
My lord, after two say date, my lord. May I pray?
Item 14 and 15, 14, Lordship, though I have received the original records, it is somehow misplaced. Let it taken up next week, any date, Lordship.
No, they were waiting here.
Yes,
14
yes,
and 15.
yes.
14.
I have informed them, Lordship.
14.
Yes, yes, 14.
What do you say, ma'am?
Yes, Your Lordship, I think it'd be more productive if we have the record.
The records are there, then we can proceed.
Yes, yes.
But next week won't be
No,
possible.
record, any date, Lordship.
Thereafter, the week thereafter, whenever it's convenient to you.
Any date, Lord.
I'll have you, can I fix it on 22nd?
Yes.
Lordship, 22nd, 23rd, I have some difficulty.
Then 27th
Yes, Your Lordship, anytime.
Tuesday, yes.
on the prayer of the parties. List this matter again on 27 to 2024.
Record article in
Yes,
that.
sure.
The
I can 100%.
Mr. SMT Siste shall keep ready the records
Yes, Lord.
as required by this court by its earlier orders.
Yes, yes.
Fine.
Yes.
Lordship, in item
Lordship,
40,
interim
The interim orders passed earlier shall continue. Yes.
in item 40, I'm appealing for response number 4 and 5. Lordship.
Ah.
I need some time to file affidavits.
Item number 40.
40.
Yes, Mr. Yeah, M. Gogoi.
M. Gogoi.
Mr. M. Gogoi, Learned Counsel for the respond number, item number 40 minute.
40,
Pray-
40.
40.
Yes.
Prays that he be granted
4
2 weeks time.
4 weeks.
2 weeks time. Every instructions have come. Both material as well as academic. Then 2 weeks. 2 weeks. 2 weeks time be granted for filing for bringing on record the stand of the respondent number 4 and 5 by way of filing an affidavit. Also, accordingly, list this matter again after 2 weeks. Are you assigning the pending? Time being to go to 7. Are you hearing it? No? Okay. Martin, close the Martin. Madam.
That industrial dispute matter, my lord.
You have seen the records.
My lord, I have, yes. But my only point that, my lord, they are very important, my lord, the Gaubua was not been examined. Because it is a fresh,
No, first,
trial, my lord, fresh trial by the
first,
trial court,
Mr. Monto,
my lord.
first question which I would like you to argue or place is whether that was permissible,
My lord,
whether that trial by the court could have been done. Department proceeding held to be unfair.
unfair.
Thereafter, they went for independently, they considered, the tribunal considered it,
Considered.
whether that is permissible. One. If permissible, then we go into the
Or the-
manner in which it was done.
Exactly, my lord, but whether it is permitted in act, my lord, I have not seen.
There are decisions.
Yes, my lord, but decision, my lord, today, I'm sorry, handicap, and at that point, I'm sorry, I'm
Because
not.
that, we'll ask Mr. Chaudhary also.
My lord, I'll only on that, my lord, yes.
First-
If I have succeeded in that, my lord, yes, very correct, my lord. I'm very sorry, my lord, and that point, my lord.
Mr.
Yes.
Chaudhary, one query is putting to Mr. Monto. He has raised a point somewhere that the inquiry, departmental inquiry, was held to be unfair.
Yes.
And thereafter the tribunal proceeded to consider the matter
Yes.
fresh. Where is that provision for that?
Section 11A.
11A. And there are decisions of the court also.
There are, I'll place those decisions.
Huh?
There are quite a number of decisions. I'm
Decisions.
ready with this.
If you can give me a one or two, so that that point
fact,
of
in
Mr.
what judgment-
Monto can be dealt with.
My lord,
In one judgment passed by Honorable Justice Manish Chaudhary, all the cases have been discussed.
That will-
I'll place that.
That will do.
Yeah, that's what I copied it, yeah. Noted to mark.
11A, power of labor court to tribunal, national tribunal.
Industrial tribunals.
Earlier prior to the introduction of section 11A, it was decided that if the departmental proceeding is held and that was held to be bad, then the management can adduce fresh evidence. And that can be taken consideration of. That particular requirement has a rider that the authority has to say, management has to say that we want to adduce evidence and that permission has to be granted. I'll show from the record that is there. And thereafter, it will be. Management of Bogapani. In fact, very interesting because that particular aspect has been kept subsequent to the incorporation of section 11A also. I'll just mark the relevant paragraphs.
Here also the issue was similar. Paragraph?
Paragraph 17. This is Delhi Cloth and General Mills. Reported in 1971 SCC, the Honorable Supreme Court of India, after discussing a number of previous decisions, has formulated the principles governing the jurisdiction of the labor court or tribunal that had emerged therefrom as under. Now, only I pause here for a while. This judgment is reported in 72 1 SCC and section 11A was incorporated.
71.
15/12/71.
So it's prior to.
This must be prior. But then, the principles that have been called out, your Lordship may come
Even
to.
para 18, workman of Firestone is
Yes,
also
that is
prior
also
to.
there. Prior to that, your Lordship may kindly come to sub 5.
Of para.
Clause 5. Para 17.
5.
Judgment of Delhi Cloth.
Has got
General
a
Mill.
right to attempt to sustain its order by
The management has got the right to attempt to sustain its order by adducing independent evidence before the tribunal. But the management should avail itself of the said opportunity by making a suitable request to the tribunal before the proceedings are closed. That was made also from the record and that was granted. If no such opportunity has been availed of or asked by the management before the proceedings is closed, the employer can
I
make
got
no
it.
grievance.
So prior to even incorporation, that power was given.
Yes.
Now,
Then-
para 19 onwards is the
Yes.
11A.
There your lordship may come to paragraph 20.
Yes, I'm there.
Firestone Tire.
Slightly confused. We provided that any proceeding under the six.
There are 37 of Firestone is one.
Sorry. 38.
So there is only one rider that management has to request and the tribunal has to grant it.
And when I was going through, there is a order, but the request of the management that I could not trace out, but
That
there
you
is an
also
order.
will find Labour Court's order at page 50 of the writ petition.
LCR.
No, in the writ petition itself. Okay. It's the order starts at page 50. Your lordship may come to page 57. Last but one paragraph. Under the above facts and circumstances, in my opinion, the domestic inquiry conducted by the inquiry officer is not free and fair, and as such, the domestic inquiry cannot be accepted as just and valid. As per the prayer of the management, the prayer was made.
This is all.
If the domestic inquiry fails and the matter is to be decided on merit, the matter will now be decided on merit.
Okay. Then followed by this.
So that rider is also fulfilled by this.
So this is the procedure. So the act is.
I think this clinches the issue and we did not go into the evidence. In fact, my lord, the proceedings were initiated against 3 persons. Other 2 persons were also dismissed, and that has been upheld by this honorable.
You have those orders?
Yes.
Similar allegations against all the common proceeding.
Same allegation of making payment
No,
to.
I'm not aware. Was it a common proceeding against all the three?
Different process.
Different.
11 into 6 will be.
It feels nice to say this. The name. Mr. Chaudhary, my name feels nice. Following it, if I have to follow it.
I am also proud to produce it.
You were on the other side.
One name will not make your Lordship very happy, my lord. That name. Both these persons were land officer.
And the petitioner is?
Petitioner is the account section clerk, clerk of account section.
So all three were hand in glove in making payment to 9 fictitious persons.
Okay. Yes, Mr.
My lord, your lordship, my lord, actually, I am very, I am not dealing much of the my lord industrial dispute cases.
Same
One thing-
here.
One thing. my
That's
lord,
why I got a
one thing, my lord, Your
clarification.
lordship, kindly see that my query, my lord, 11A, 11A.
No, there is a decision.
No, I am not on that. Your lordship, kindly see the proviso.
Hmm.
No, my lord, there's a little confusion in my mind.
Provided that in any proceeding under this section, labor code, so and so as the case may be, shall rely on the materials on record and shall not take any fresh evidence in relation to the matter. So
So what is, my lord?
this is already interpreted by the Supreme Court.
But Act itself says that you
Fine.
cannot take new evidence.
Supreme Court interpretation I'll have to follow.
That means you have to prove the case by new evidence. But you cannot rely on the other because
No, that is gone.
that gone. We cannot discuss the other evidence.
No. That evidence is for all times gone. Management has to make a request. If the request is made, the tribunal can accept it. And if it is accepted,
Then they
that
can
proceeding-
take evidence.
that decision of my Lord Justice Chaudhary in WPC number 1962.
One
1962 of 2013. And it has said that this is not a statutory right. This is a right flowing from the judgments of the Apex Court.
That means that proviso is meant, my lord, will interpret.
Has been interpreted.
Then, my lord. Very funny. Apa kita sih?
I'll go through it, don't worry. You can also examine that if you want, that decision.
That's why I'm submitting that is in very clear terms, my lord, it is in section. It is very clear terms.
You place, I'm open, I'm ready to
My
learn.
lord,
I'm here also
that's-
to
I have
update
not
myself.
gone for that
Mr.
judgment,
Chaudhary
but
has
anyway.
placed this,
My lord,
but if there is something contrary, please, we'll consider.
my lord.
If that be the position, then your case gets narrowed down.
My lord,
Then it becomes like a normal disciplinary proceedings.
then,
You will have to show prejudice now. Anything. You were given a scope to produce evidence.
yes, but only myself I was produced, my lord. No, but management, my lord, what is the duty of the clerk, land clerk, my lord? He is present in the field from the land account sections, my lord.
That we'll get a clarification. Mr. Chaudhary, what is the allegation against him and what was proved?
In fact, his writ petition itself explains that. And the evidence there. If your lordship kindly comes through
the impugned order of the tribunal, there it has been discussed elaborately. What is the duty of a accounts clerk?
No, the allegation against him. Duty of fine.
The duty of the land staff and the accounts officer, they all of them go to the place, identify the persons, identify the land, put their signature, send it to the office, and the record is maintained.
Okay.
He's one of them.
Now, where is the show cause notice issued to him in the matter?
Page 30.
Page 13,
1-3.
page 13, 1-3.
1-3.
And this was the allegation against those two persons also.
Yes. Same allegation. And his reply is at page 15. The only two ground that has been sought to be made out in the reputation is that he was not given a copy of the documents. So those are not supplied, and the inquiry report was also not supplied.
There is one more ground.
But this was not a ground taken in the show cause.
No, there is one more ground that he was not given an opportunity of cross-examination.
No, that will be reflected from the order of the tribunal itself.
In paragraph. Okay. Para 28 you are referring to.
Yes.
28 of the petition, page 10, where he has reiterated that. Okay. So, let's say three grounds. Procedure in the tribunal, he was prejudiced for some extent. That may be one of the arguments. Second argument is documents were not given. So, on that, what is the finding?
From the reply, his reply itself, it is shown that he did not ask for did not agitate the matter that he was not given the document.
He was prejudiced in submitting an effective reply. He did not agitate that.
Yes, he ought to have taken that ground on the initial stage itself. Page 15, your lordship will find he doesn't have that ground.
That. Okay. Yes, Mr.
No, my lord, that your lordship kindly in para 28, how they replied, my lord. India's affidavit in reply.
Page. Affidavit opposition.
My lord.
Okay.
The submission made in paragraph 17 and 20 of the petition, neither tenable in law nor in fact as such same is liable to be that the issues or defense were not answered by the learned getting in never court in so and so. The deponent stated that while learned court below has held that they did not find any inherent illegality and impropriety in dismissing the workman and that the workman has been rightly dismissed. There is no question of not answering the issues referred. The petitioner rightly dismissed the dismissal as the appropriate punishment for misconduct like corruption, etc. Denied that the learned court below has misconstrued the provision of standing order that it is not applicable in mind. He also denied that the findings of the court below perverse and illegal. He also denied that vital witness were not examined alleged by the petitioner. Since the inquiry was already held to be not fair, the question of being the domestic inquiry again does not arise. So they have answered that, my lord. So since that is held to be illegal, so there is no question of bringing this document again. So that is their reply, my lord. Now, my lord, if your lordship, my lord, see the evidence taken by the level court, my lord, what is the most foremost, my lord, most important witness was what, my lord? Important witness was Gaubura, my lord, who identified the persons, my lord. So what is the duty of the, my lord, land clerk, my lord? That has to be very important. Your lordship kindly see exhibit 34, my lord.
Where is it?
Exhibit 34 in the
Oh, yeah.
record, my lord.
Record.
Page probably 113, my lord.
34.
113, my lord.
34.
Page exhibit 34, my lord.
Yes.
Procedure for payment of surface compensation. As you lordship got it, my lord. On subject mentioned above, we'd like to inform you that there is no such written guidelines or manual which you covered all the questions raised by you. However, after going to the record of the various individual files pertinent to the various locations subject taken over during the procedure, I mentioned you like following facts are to be right, which in finished by underquoted annexed as following. 2.0. Please note that the procedure which are explained to above annexed have undergone change recently with the introduction of new land acquisition policy.
You will have to come to Annexure 2.
Now Annexure 1, my lord, that negotiation and for investment.
We are concerned with 2.
My lord.
Initial process of confirmation of an.
Presence of land and accounts visit the site and list number of standing crops and asset in presence of the concerned occupier and village headman.
Where
In
are you
absence
reading?
of village head.
Where are you reading?
My lord.
Reading?
Annexure 1, my lord. Kindly see Annexure 1. 112, page 112.
The actual process of innovation stands
My lord.
solely after completion of demarcation, so and so, question by the survey. The representative of land accounts will visit.
This is regarding not, my lord, regarding the compensation of land. It is a compensation of, my lord, standing crops only.
2020. Okay. Subpara.
Two.
Two.
Subpara 2, my lord.
No, second, 2.
The representative of land and account visit the site and enlist number of standing crops, because my case is related to only standing crops, not land, my lord. Assess in the presence of concerned occupiers and village headman. In absence of village headman, the assistance of the nearby village headman or
Wait further. Or prominent persons.
prominent
village
person of the
headman is
local-
not without the village headman also it can proceed.
but prominent local man.
Okay.
Who is well aware of the inhabitant of the respective locality and identify the crops it's taken, because the landholder, my lord, from the record, but standing crops, my lord, that is, my lord, the Gaubura's help is required, because the person who is the, my lord, owner of the.
You are going there to
No,
see.
Then your lordship kindly say Annexure 2, my lord. Annexure 2, page 110.
Yes.
The Annexure 2 has your lordship. A, basic of identification and occupier. Initial process of confirming an affected occupier or patadari the proposed land required and stated with the collection of Siddha Accord and cadastral map of the concerned revenue cycle officer. On the basis of the said record were processed toward the particular locality through the Gaumbura on his absence. So the person has already mentioned in Annexure 1. We cannot, we contract the person whose land may be probably be involved in the obtaining the consent of the part of the land.
Okay. Yes, I've got it.
Now, my lord, Annexure 3 also very important, my lord.
Please proceed.
Annexure 3 also, then the stateway goes to, my lord, page 88, my lord. Rule of land clerk in the acquisition of acquisition of land prior to the year 1998.
Annexure 3.
No, that is, my lord, probably Annexure. No, Annexure 3 is, my lord, procedure, same, my lord. Then that rule of the land land clerk to during the acquisition of land.
Page.
Page probably 88.
Here is your supers.
No, that 109, page 15, difficult to matter whether it is on record or not, I do not know.
Okay, if I've understood the thing correctly,
Enforcement of the marriage.
if I've understood the issue correctly, you were to go before in the site, you and others.
Which is by ballot idea, which is ballot authorized by the department.
Fine. You go to a site, say site A. You have demarcated the land, everything is done.
No, not demarcation.
No, others.
Others.
Demarcation. You go there and you find out who the occupier of the land is.
My lord, the standing cops.
That identification will be by the Gambura or by any prominent person of that.
Any of the land department clerk? Any of the land department clerk? Your lordship kindly mind it.
You are not a land department clerk.
I am not land department. I am from the accounts department.
Okay.
So my duty is to, my lord, how many cops are there?
No, that's what I'm saying. You go there. No.
And
you go there. Say my land. You come to my land. This is my land. You make an assessment on being identified that this is the land of mine.
No. That land, I am not identified, that Gambura also not identified who is the owner of the land, who is the owner of the crops, standing crops.
That's what I'm saying.
My lord,
Crops
sometimes, my lord, land of the owner and crops owner of the
may be
crops are
different.
different.
So once you say there are 10 trees,
Yes.
there is paddy, there is so you make a list and you give it.
No. My duty, yes, there is 10 trees and that will 10, suppose one tree that is my lord calculated as 100 rupees, then 10 into 100, that is my duty. So calculate that calculation because I am from the accounts department.
So you make that enumeration
Now
list.
allocation is
You
there.
make that enumeration list of the trees,
exactly.
of the crops, trees, whatever it's growing in that land,
my lord,
standing in that land, you
My
make a list
my lord,
and you give the value.
my lord.
Right.
Other things, my lord, the clerks from the account department, that means land department, and he will identify, and I have to put signature there, my lord. Yes, that is correct. As per their norms, my lord, standard there, my lord, that both the department has to go there. So now Gambura identified those persons.
What prevented you from calling the Gambura?
No, I am not calling. That is a procedure that has to come.
No.
I am
The
not calling.
in the inquiry, they have not called, but why didn't you call him as a defense witness?
I call him in the defense, but he said that it is not my signature. If it is not his signature, it is sent to the my lord FSL.
Signature was taken in front of you. Yes.
Me and my lord land clerk. But I cannot put question to him. That is not my duty. So that Gambura is not been my lord. He's a Gambura of the my lord Sarkari Gambura. He was not examined before the tribunal, my lord. We cannot go back to the evidence of the my lord inquiry before the inquiry officer, my lord.
Okay. Now, what is the fault in the judgment of the tribunal?
My lord, your lordship kindly that 9 vouchers. That was after calculation. I sent it to the accounts department, higher authority, my lord. Pay the check to the concerned persons, my lord. So they can, if there is a fictitious person, they can, my lord, find it out from their accounts because account been checked by the my lord higher authority, not by me.
Account?
My lord.
What account?
There are allegations against him in this case that 9 persons were fictitious persons. So their name, their check has been issued. So this check, my lord, is issued by the accounts department. The name, my lord, which was identified in during that period, my lord. So that was the account-based check, my lord. So easily they could have find it out those persons. But that was not done. I am not on that. Those vouchers has also not been produced before this, my lord, tribunal, my lord, labor court, my lord. So, my lord, your lordship kindly see the evidence of the, my lord, by that workman, my lord. He has clearly stated, my lord.
Okay, where is that discussion on that point in the...
My lord. In the judgment? My lord.
Now, Mr. Chaudhary, in addition to this case, there were other cases, proceedings also against him.
Yes, there were four proceedings.
Then what happened to those?
Because he has
You
been
had dismissed here, so
here,
that was not
those
proceeded.
are kept in abeyance.
Well, they have filed a criminal case also, criminal case I got acquitted, madam. But regarding other 4 cases, my lord, no decision has been taken, that's why no challenge made, my lord.
Yes, Mr. Moto, you can proceed.
Yes, my lord. But that para, my lord, I just find that para, my lord, where the principle is. Para 9, my lord, during the course of the agreement, the learned counsel for the workman has contended that the FSL expert has not been examined and it has been left on the expert opinion cannot be relied upon. In support of this agreement, the learned relied upon the 2009 9 SCC that considered the same. This learned counsel for the manager on the other hand has submitted that no objection has been no prejudice has been caused to the workman according to his section 45 evidence. Expert opinion is a mere opinion. Having heard the both sides, it is not find any concern considering reason. Because an expert, it is again submitted that in behalf of the workman that the Gambura has not been examined. It has again submitted on the behalf of the workman that the Gambura has not been examined, on whose statement entire case is originated. According to him, non-examination of the Gambura is a fatal due to the course of management. It is a clear violation of the principle of natural justice. In support of this argument, he relied on the decision in the report of so-and-so 169. I have produced the observation arrived at the Honorable Supreme Court. The learned counsel for management has emphatically submitted it is admitted position that the workman put the signature in his enumeration list. From the evidence on record as well as from the exhibit document, it does abundantly clear that the workman had active participated in the preparation of the enumeration list, which is put his signature. The learned counsel for the workman argued that the workman simply put his signature on such no liability can be stated on him. He cannot say to the said eye to eye with the on this point. Evidence transpires that another 4 charge sheet a similar offense has been filed against the present workman, which has been disputed by the workman. From this conduct, this also appears that the workman is having tainted integrity. The learned counsel for the management effect of his submission contended entirely that where charge of the misconduct has been proved, the punishment should be dismissed. In the support of the evidence on so-and-so, the committee business so-and-so, in case such nature of decided so-and-so, then my opinion, punishment has dismissal. Any sympathy shown in case of the totally uncalled for oppose the public interest, the amount of misappropriate may be smaller or large. It is the act of the investigation of the relevant. Reliance can also be placed on the 1997 11 SCC 370. The learned counsel for the management also submitted that the land clerk who committed the embezzlement of the company's money along with the present workman has already been dismissed from service, and his dismissal was salient in the similar was for the disposal of paid insurance. Since the present workman is in the same footing, it has faced the same consequence. Having regard to the both sides, having considering the evidence on record, having dug the regarding exhibit document, I am considered the whole that a charge of misappropriation has been fully established. Accordingly, to me, the workman has been rightly dismissed from service. So that was the finding, my lord. Regarding my lord, non-examination of Gambura, non-production of the my lord, that voucher.
Mr. Chaudhary. Going by the Annexure 3 here, that procedure an accounts clerk is to do, you have laid it down. That he is to go there with the land department clerk in the presence of the Gambura, who will identify the person, and thereafter a list is to be prepared of the standing crops. I'll use the word crops, maybe trees, maybe whatever it is. And then he will forward it to you. Thereafter, he has got no rules.
He has got road.
What is that?
He prepares the vouchers
For payment.
for payment.
That was not highlighted in the order, in the judgment.
No, my lord, in fact, this has been discussed in the judgment. It has been discussed. He prepares the voucher and makes the payment.
Payment can be made by him on his own, or there has to be an approval.
It's 69.
69.
69. In
The account clerk prepared the payment, yes. Account clerk prepared the payments, vouchers, and thereafter payment is made. Now tell me one thing. If the person in a village is identified by the Gambura or a prominent person of that locality, and he says, this is my land, and he prepares a voucher against me, he has not committed any wrong, because he cannot be knowing who I am,
Yes.
because that is not his duty to find out. It's for the Gambura to identify. Now, if that be so, what was that thing he did which led it to a misconduct?
The identification of a person by the Gambura in the presence of my lord land staff and account staff, that has been identified, he has put his signature on that. That means this person is identified. And the
Say
particular...
Mr. K. Kolita is identified as that land man who is the owner of that crops. We'll say owner of the crops. Then what he does? Then what happens? I'm the Gambura, I identified Kolita as to Mr. Mohanto, that Kolita is the man.
Yes.
For this parcel of land. Then what? Then he makes that enumeration. That this much is here. This much crops are.
Yes.
And then the value of the crops is made out.
Yes.
And then he prepares the voucher. That voucher will have to be approved by some authority somewhere. And he makes the payment to Kolita. Now, in this case, what has happened? The payment to Kolita after being identified by Gambura is bad.
Yes.
Why?
For that, my lord, that has been discussed in the earlier judgment also.
High Court.
High Court judgment. The case built up in the other case, in the High Court in Ruchinath Borua.
Ruchinath?
Phase 2, your lordship will find name of the particular occupier, these are the 9 persons, 4,26,000. Then 1.0b, the concerned Gambura who identified the occupier particulars of the LOC MTC stated that he had neither put his LTI nor seal on the above mentioned enumeration list prepared by you. Further, he reiterated that the 9 persons as mentioned above do not hail from the village under his jurisdiction.
So the charge is, the allegation actually is the persons who have been brought on record are not the persons who have been identified in terms of Annexure 3. Is that the case of the oil?
No, the case is that the persons have been identified by them.
Not by, means I'm not saying that. Identification is to be made in terms of Annexure 3.
Yes.
Exhibit 34. The identification they have made is not in terms of Annexure 3, but their own, this people conspiracy, and they have done it. Is that the case?
Yes. Now, the 2 points he had earlier urged, I have got answers to that. Regarding the providing the documents and regarding the cross-examination. Regarding the providing the documents, your lordship may kindly come to page 41. That is his written statement. It starts at page 36. Written statement for an on behalf of the workman. Your lordship may come to page 41.
But Mr. Chaudhary, once that proceeding itself is gone, should we go back to that? Whatever prejudice is now being caused to him should be finded out in the trial, before the tribunal.
Yes.
Going back to the other
Therefore,
proceeding
we did not
it's
go
gone.
to any evidence at all, my lord, but that ground he had taken, that is, my lord, falsified by this statement at paragraph 11. Page 41, paragraph 11.
That a copy of the
Inquiry
inquiry
report was furnished to the workman and he submitted his representation before the gentleman against the findings of the inquiry officer. Then the second issue was regarding the cross-examination. Which your lordship comes to the interim judgment. It starts at page 59. Your lordship may come to the discussion on the witnesses. Page 64. Paragraph 7. Now I like to discuss the evidence adduced by the management vis-a-vis the evidence adduced by the
there is a reference of his cross there.
cross-examination against every
That I've seen.
everyone.
That I've seen. And the other cross in the departmental proceeding is of no consequence now.
In the departmental
So that is
proceeding,
already held to be bad.
yes.
But Mr. Chaudhary, just a moment, I'll just go through this one. Maybe that will clear up. And one more, the findings in such an inquiry before the tribunal, in such procedure adopted, will again be preponderance of probabilities.
Yes.
It cannot be beyond reasonable doubt.
Because he may have been, his house was raided by CBI and eventually he was acquitted.
That's a different thing altogether. We not. But here, again, like a departmental proceeding,
Absolutely.
it's just a departmental proceeding
Absolutely.
before the tribunal. Sorry, I'm just trying to understand the issue.
Page 70, the third signature.
And in that case, in Ruchinath Borua and Lohit Raskor, finally this court remanded back the matter saying that impose some other penalty. Last paragraph.
Voluntary,
Compulsory time, anything.
compulsory time.
That including the penalty of compulsory time. What happened then?
That is still pending. Will be dismissed from service. Now, I'd like to draw your lordship.
Okay, liberty was granted, that was
Yes.
not exercised,
Not-
fine.
And regarding that signature of the Gaumbura, yeah, I have already shown that the Gaumbura did not sign. And if your lordship comes to page 68. Your lordship will come to last line. Page 68, as your lordship got it. The specimen signature of Gaumbura Kiang Larong Singfo was sent to FSL for opinion on request of the workman PK Shah. On his request, it was sent to FSL. Then
But the FSL gave a contrary report, then it was held that it is only an opinion.
No, what I am
No, no,
saying,
it was not
I'm
like that.
saying that what is the opinion? Page 70, the forensic, my lord, it is a little below, in the middle, forensic science laboratory to verify the genuineness, but the experts held that the signature of Kiang Lerong Singfo was forced. So what they did, they went to the site, these three persons, identified the persons and forced the signature of the gown.
to make it in compliance with your
Yeah, or
Annex 3.
Annex 3.
Okay, that was again gone into by, at, I think, paragraph 9, page 74.
During the course of the argument, learned counsel for the workman has concluded the FSL expert has not been examined, and for this slab, the expert opinion cannot be relied upon. In support of his argument, he relied on substances I consider the same. The learned counsel for the management, on the other hand, submitted that no prejudice has been caused to the workman. According to him, Section 45 of the Evidence Act says expert opinion is a matter of opinion.
And even the examination of Gangpura was there.
Exemption of Gangpura is fatal to the case management. It is a clear violation of principle necessary. In support of his argument, he relied on so and so. I have perused the observation arrived at by the Honorable Supreme Court. The learned counsel for the management has empathetically submitted its admitted position that the workman has put his signature in the enumeration list. He has not disputed.
Can you just go a little bit further? From the evidence on record,
As well as from the exhibited documents, it is thus abundantly clear that the workman had active participation in preparation of enumeration list, and wherein he has put his signature. The learned counsel for the workman argued that the workman simply put his signature, as such no liability can be fastened on him. I cannot see eye to eye with him on this point. Evidence transpired that another 4 charge sheets of the similar offence has been filed against the present workman, which has not been disputed by the workman. From his conduct, it is also apparent that
so, Mr. Monto,
My lord,
that fact that your signature therein,
my lord,
your signature in that list
my lord.
was admitted and said that you can have no liability, but it is you who had the responsibility of protecting the interest of the company. What do you have to say on that? The materials as it has been placed. Forget the Gangpura.
No, my lord,
If the Gangpura was not there,
no, Gangpura was there. He find his signature. My lord.
no. You could have called him as a witness. Why did you not call him?
No,
as a-
before my lord.
Before the tribunal.
Before the tribunal, my lord, I cannot, my lord.
Why?
The tribunal has to, my lord, because it is
Why?
their
Have you put in a-
management,
no,
because
no.
management has to establish there, my lord.
No. Have you put in an application before the tribunal
My lord,
that this witness is required to be called? There is a provision under the Evidence Act.
correct.
An Evidence Act, at least
No.
spirit is applicable there.
No, whole case is that, my lord, the Gangpura signature, my lord, on the basis of the Gangpura, that, my lord, that is the duty of the management also to prove his their case, my lord, because they put me in my
No,
charge. my
at
lord.
least, Mr. They did one thing. They brought on record a opinion, FSL opinion.
My lord,
Right, wrong.
opinion, my lord, that's why
Opinion
that-
is opinion.
No,
Okay.
opinion is opinion, but my lord, that is also I am unable to, my lord, cross-examine him. It is also not been produced
No,
before
no,
the
no.
court.
I'm not on that. In that light, why did you not file an application saying that this evidence or this manner is bad? Call the author. Call the Gangpura. They deliberately did not call him. Rightly so. They deliberately. They have been caused up.
That is the
But
case.
you accepting that would show that non-examination of the that a witness did not cause a prejudice to you at that point of time. Mr. Sharma, is it, Mr. Chaudhary, is it permissible that you did not produce a witness, but you produced an opinion? He disputes that. Can he call the or make an
How can I,
application
my
to
lord?
the
I cannot,
tribunal?
my lord, I cannot.
the
In
defendant
labor
can-
court, my lord, I cannot.
the defendant can
I,
ask for producing the plaintiff as a witness.
Then
I cannot, my lord, because in labor court, my lord, so far my knowledge goes, my lord, that management, my lord, that list has to be given prior to that, my lord, because to defend, they are not
Okay.
examined, I am taking the
Okay.
advantage of it, my lord.
Okay.
I have to take
Management had
advantage of
given a
it, that is
list.
there,
Management had given a list.
my lord,
Management had given a list of witnesses.
my lord,
There was no Gangpura there.
my lord. No, that is why, my lord, if not then, my lord, that is goes advantage in my favor, my lord.
Fine. But they got a FSL report. I say just trying to this is not a pure civil proceeding or a pure
Exactly,
criminal
my lord.
Oh, CPC
The-
applies.
CPC will apply. But
No, speed will apply, my lord.
spirit
because
will apply.
Your lordship,
Forbidden as
in
it.
labor
Let's
court,
say CPC applies. But If that opinion was there, why did you not direct the tribunal? Okay, show me a written statement wherein you have, or anything, any material written place, written argument, anything placed before the tribunal during the course of the hearing, anything of that sort.
An argument, my lord.
Yes, Mr. Chaudhary, forget this, just for my understanding. In such a situation, if that is a vital witness, because everything hinges on him, that Gampura's evidence, because he is the one who projected to be argued or projected to have identified the plot or identified the person. FSL report not proved. FSL report, the author was never there. So I don't know how much credence we can give to that. Then in such a situation, if this is the situation, what would be the options?
I'll just check, my lord, whether I'm just.
Because everything is moving here, holding that the identification made, that signature of the Gampura is forged.
Even without that, the person, he has to identify the particular land, the owner of the land, and in the
No,
land.
that is the
Land-
defense he is taking, Mr. Motta.
Yes, my lord, who is the owner of the land? I-
Has to stand on some land, and to become the owner of the crop, he must be the owner of the land. If he is not the owner of the land, there has to be some explanation for that. But what is that? So the land has been identified, owner has been identified.
Land identified. Your procedure does not require him,
Yes,
does not require him to match the Jamabandi and the person. The procedure only requires that he will proceed there with the lands department staff. I'm forgetting the others. I'm only asking his involvement. Proceed there, and then the Gampura will say this parcel of land covered by Dag number, Patta number, whatever it is, belongs to Concolita. Signs it. He makes the enumeration calculation, gets the signatures. Now, to make it an misconduct, you will have to show that the very identification made is wrong.
My lord, the land staff and the account staff, they are a team. They are a team. It's not that only because you are they are one party, you are liable for one part, you are not liable for they go as a team from the Oil India.
So your case is that the identification that was made by the whole team,
he is also part of
it. That identification was wrong. Now, second question. The procedure requires them to make this identification not on their own.
With the Gampura.
Gampura. Now, Gampura
and the team, my lord.
And the team, whatever it is. Say 5 people team going.
Yeah.
The team will meet the Gampura or a prominent citizen and then identify Concolita, whoever Concolita is, because they will know. And once Concolita is identified, the people will sign.
Yes.
He will sign. Right? Now, if that signature of the Gampura, say you are the Gampura, is wrong, that is forged by Mr. Mohanto, let's say, forged, your signature. MKC Chaudhary, he has written forged. Now, either you will come before the tribunal and say that, yes, I was not there, this is not done by me, or you will get, the authority will get an FSL report. You coming and saying, he'll get an opportunity to cross you, finished. End of the matter. Whatever comes out, comes out. FSL report, if the authority who has done it, the expert, is not brought for examination, what is the value of that opinion?
It's an opinion.
It's an opinion only. It's not an evidence now.
Yes, but then.
So in that context, that lacuna, what is your explanation? Only that much. Others think I am satisfied. Only that much.
My submission will be that, my lord. The Oil India.
I'm sorry, it may be a very irrelevant question, but this is something troubling me.
First thing, my lord, this ground has not been taken. So.
We have taken it. Equity could.
Yes, it's an equity code. Now three persons go as a team. And now one person says that, no, I'm responsible for this part only, I'm not responsible for the other part.
I say, let's forget that. Say all the 5 are before
They
me,
go
before me.
and the ground Bura is not there. So they give a for signature. And who is the beneficiary of that? Some fictitious persons.
Fine.
So your party to that.
But Mr. Chaudhary, if that identification is made by the Gaon Bura, then it is the Gaon Bura who is liable, not they.
Examination asani go. I think he has been examined because in the earlier order of
He was examined before your that departmental proceeding, I suppose, but not here.
in that case, my lord, the annexer 3 also a part of the earlier evidence only.
No, fine. Fine.
Anyway, we do not dispute that.
But I just want this thing because I'm here to do, I'll have to balance both sides. But if this is the lacuna, it affects the whole proceeding because everything boils down to that now.
That has been the
I understand that he had done a mischief.
Mischief.
Big mischief, misconduct. But you will have to connect him with materials. The learned tribunal had gone and connected him, ignoring this aspect, although it was brought before its notice. Gaon Bura part was brought before its notice. It said, okay, fine, this is not there. Other documents and evidences, it is proved. But if the Gaon Bura is the one, or
I get your Rosh's point. I think for that, perhaps we may
anything, how should I now deal with this point?
Perhaps we may have to go to the provisions that have been, my lord, culled out in explaining section 11A.
Fine.
There, the evidence, although, my lord, the evidence, fresh evidence is laid, other evidence that has been laid, those are not completely wiped out. Because
Can you just show me that? And then take me to any evidence in the disciplinary proceeding or disciplinary proceeding in the departmental proceeding, which can be,
I'm just trying to check that, madam. I think
we can have it on Thursday if you want. Getting interested, but I want an answer on that.
Yes. This
Only on that
point is very interesting. I admit that. I admit that.
Because everything boils down to that issue. Because, Mr. Chaudhary, the tribunal must be satisfied. That is what the Supreme Court says. If you come to Firestone 16, para 20.
Yes, I am reading that, para 36 of the judgment.
36 of the middle portion. You will get.
Yes, this position in our view now has been changed by the section 11A.
The words in course of adjudication.
In course of adjudication proceeding, the tribunal is satisfied that the order of discharge or dismissal was not justified, clearly indicates that the tribunal is now clothed with the power to reapprise the evidence in the domestic inquiry and satisfy itself whether the said evidence relied on by the employer established the misconduct alleged against the workman. So that can also be considered by the tribunal.
No, I don't think so. That is in
what was originally a plausible conclusion that could have been drawn by an employer from the evidence has now given a place to a satisfaction being arrived at by the tribunal that the finding of the misconduct is correct. The limitation imposed on the power of tribunal by the decision in Indian Iron Steel is no longer be invoked by an employer. The tribunal is now at liberty to consider not only whether the findings of the misconduct recorded by the employer is correct, but also to default from the said findings if a proper case is made out. What was once largely in the realm of satisfaction of the employer has now ceased to be so.
Mr.
And now it is
Kolita,
the satisfaction.
Mr. Kolita, if there is any evidence of the Gaon Bura in the inquiry, just try to find out.
So, my lord, in my humble understanding, perhaps, my lord, that is also not completely wiped out. Because the subsequent evidence laid in the inquiry is only additional evidence. Paragraph 37, if there has been no inquiry held by the employer or if the inquiry is held to be defective.
To adduce to regarding the legality and validity of the domestic inquiry.
who were not inclined to accept the contention of the workman that the right of the employer to adduce evidence before the tribunal for the first time, recognized by the court in this various decision, has been taken away. There is no indication in this section that the said right has been abrogated. If the intention of the legislator was to do away with such right, which can be recognized over a long period of years and will be noticed by the decision referred to earlier, the section would have been differently worded. Admittedly, there are no express words that to that effect, and there is no indication that this section has impliedly changed the law in that respect.
Okay.
I understand that, my lord, the tribunal has not been debarred from looking into the earlier
evidences.
Those are evidence on record.
Because it's a procedural error maybe.
Yes.
Which leads to
Holding
the
that-
Supreme Court saying that you can now do it. So that the workman gets a scope. Yes, Mr. Monto.
My lord, your lordship kindly see the cost
But
of
please
the.
examine as to that question that I put. Whether if there is some evidence, it's fine. Before the tribunal.
No, that is
But-
there. Before.
No, sorry, before the inquiry.
That is there.
Gangura had come.
Yes.
Deposed.
Yes.
Show me.
Gangura has deposed and he said that has been reflected in the order of the Honorable Justice B.K. Sharma.
Please show me. No, that two cases you gave me.
In B.K. Sharma.
Wherein the matter did not reach the tribunal, it finished before there was no fresh inquiry in the tribunal. It finished with the proceeding itself.
In Lolit Raspur case, paragraph 13. It was alleged that the particular signature of the Gambura was forged. The said Gambura had made a statement that the signature appearing in the related documents on which the petitioner had countersigned was
No,
forged.
it is submitted by Mr. Learned Counsel that the Gazette Gambura has not been inquiry statement and FSA cannot. However, from the above quoted portion of the inquiry report, it is crystal clear that the petitioner himself declined to cross the Gambura. Contradiction. Contradiction here, para 13. Your submission, Gambura having not been examined in the inquiry.
Yes.
His statement and FSL report cannot be believed. However, from the above quoted portion of the inquiry report, it is crystal clear the principle where is that above quoted portion.
The cross-examination was not done. That means that he was examined.
But your submission was he was not even examined.
Yes.
Well, what is the
So
position?
now we'll find out from the record his the evidence of the Gambura. My learned friend is trying to find out.
Okay. Mr. Monto, you want to conclude today?
Yes, my lord, I want to read the first section of the management witness, my lord. These are management witness, my lord. But very clearly there is a indication, my lord. It appeared from the record that the signature of LTA of the concerned Gambura was obtained by the land clerk, not by me, my lord.
Okay,
So that everything, my lord, in my lord.
Fine, I got it.
My
You
lord, I
continue.
place all this, my lord,
You continue. Continue.
my lord.
You can continue.
My lord. Your lordship kindly see, my lord, that cost MW6, my lord. Management witness 6, my lord.
PW 6.
Management witness.
Page.
6. It will be in record, my lord.
What is the name of the witness?
Dinonath Prasad Gupta. Dinonath Prasad Gupta.
No, not Prasad Gupta. Dinanath Prasad. Right.
At cross, my lord, cross examination by the workman.
We have to finish up this case very soon because the documents are in a very bad shape.
My lord. At the relevant point of, has your logic got it? ma'am?
Cross.
Yes, at the relevant point of
Just a
time, I was the
Just a
vigilant.
moment, just a moment. Cross, yes.
At the relevant point of time, I was vigilance inspector and I was.
No, this is 7. Just a moment.
I'll go to 7 also, my lord. 6 is important, my lord.
I think it's recorded behind the. Okay, cross examination. Yes.
At the relevant point of time, I was the vigilant. Is your lordship correct, my lord? I was inspector and I visited the locality and recorded the statement of some person, including the Gaubura. Accordingly, I submitted my report to the department. On the basis of the report, disciplinary proceeding was initiated, followed by a search. The workman Pranab Kumar Sharma was working in the accounts department of Oil India Limited. Liaison at the 11th time, the Oil India Oil is having a full-fledged land department. When the Oil India requires some land, then the land department may propose to government department for acquisition of land. If so required, as sometime ago, Oil India may themselves direct the purchase the land from the Pattadar owner and occupier if the situation so arise, the land involving the particular case was purchased by the Oil India. This purchase was made by the execution of sale deed and the owner. Land department ascertained as to who was the owner of the land. Before execution of the document, the payment made to the owner of which is followed by the execution of sale deed. I do not know whether the sale deed was executed or not in this particular case, but some payment were made to some person. The payment was made to the concern with the surface compensation and value of the land. The part of the standing crops, if any, fixed by the deputy commissioner, and therefore the calculation made by the land department on the basis of the rate fixed by the deputy commissioner. For the purpose of the assessment of the surface compensation of the official land department and the accounts of the department go to the spot and calculate the numbers of trees and the quantum of corpus, if any in the Zirat is present, therefore the surface compensation is paid on the occupier landlord as their case may be. In the service team where some official accounts department whose duty is to make necessary calculation, summary of the payment statement has to be prepared by the land department, which will be indicated the name of the persons who own the payment or are to be made. Indicating the details of the standing crops. The land department, after ascertaining the standing crops and trees, send it to the accounts department for necessary calculation and payment. The rule of the accounts department is to ascertain whether the calculation made by the land department is correct or not. In the instant case, the calculations were made by the accounts department. Generally, the accounts officer used to direct the account concerned clerk to prepare the payment voucher. In the instant case, whether the concerned clerk was directed to prepare the payment or whether or not is not clear to me. As part of usual practice, accounts officer required to sign every page of the summary statement for payment of surface compensation. Details, particulars of the surface compensation are also be indicated by Exhibit 22 series. Summer sheets were physically checked by the Mr. L.K. Rajkhwa, senior land officer. Statement of the surface compensation are also verified by the accounts department on the basis of the summary report by the letter dated 9/2/91. Exhibit 22, manager of land requisite and general manager finance and accounts to arrange for payment of sum of rupees 7,43,180 to the occupier Pattadar being the surface compensation. Therefore, the payment vouchers were prepared and thereafter payment was made. Account clerk prepared the payment voucher and thereafter payment is made. It is usually practiced in the accounts department will prepare the payment voucher and thereafter check were issued by the cash branch to the account department and the same are collected by the land department from the disbursement, and payment vouchers were prepared by the workman Pranab Kumar Sharma. We have not exhibited the voucher prepared by workman Pranab Kumar Sharma. I do not remember whether those vouchers were produced at the time of inquiry, department inquiry. while I was conducting the preliminary inquiry, the payment voucher were not available. When I visited the spot, workman did not accompany me. I recorded the statement of the English, so where the statement was recorded in the mirror. Not, I have also recorded the statement of the Gaubura, so that amount were disbursed by the land department to R.N. Borua, land clerk, and L.K. Raskwa, senior land officer. So, your lordship kindly see what is my duty, my lord. So I was present in the field just to calculate the trees. I am not it's not my duty to identify the person. So now, my lord, your lordship kindly see cross of the management witness number 7. Cross of the management witness number 7, my lord.
Yes, I've seen it, Mr. S.K. Dekas.
My lord.
S.K. Deka.
Yes, Sarush Kumar Deka.
He was the presenting officer.
Yes, my lord. Yes, my lord, he clearly stated, it appeared from the record that the signature and LTA of the concerned Gambua were obtained by land clerk. So I am not land clerk, my lord. Yeah.
In the cross, last page, top portion, he says land clerk as well as the accounts clerk.
So that is not my duty, my lord.
No,
By
both of
present
you
there,
together.
so my duty is to, my lord, how many trees are there, how many crops are there, that is my duty, my lord. It is
And
not a
all
case
the-
that
no,
there is
no,
no.
all the vouchers or the, what do you call that statement, your signature is there. And identified by LTI of so and so.
But payment was made through, my lord. Your lordship kindly see.
No, the person identified by you to the Gambura is the person whom the payment was made.
No, identification in that field, my lord, your lordship kindly see, my signature is that, so far his identification is part, my lord, that is signature in presence of the land clerk, my lord.
So, Mr. Chaudhary, in the vouchers that have been prepared for payment, if we can call it vouchers, that receipts which are there also the signature of the Gambura, or the thumb impression of the Gambura.
Yes.
That is also to be held to be forged.
Yes. That is there in the
LTI.
statement of,
Huh?
that is there in the management witness that has been taken.
That has come.
Yes.
Therein the signature of the petition is not there. It's only the person who received that money.
The picture that we get is that these 3 persons from land and accounts, they went there. No person, fictitious person was not there. Some
Okay.
fictitious name.
This is the statement. Gambura in the domestic inquiry. I say so and so, I have not put the LTI and rubber seal stamp in the enumeration list prepared by oils official, which I have checked today. The rubber seal stamp put on the enumeration list, which are shown to me by Sri Deep N.P. Gupta so and so, do not resemble with my rubber seal stamp. I further assert confirm that following 9 persons do not hail from the villages of my jurisdiction. Statement furnished by so and so to D.N.P. Gupta. D.N.P. Gupta was the inquiry.
Who person who disbursed the check, my lord, your lordship kindly see.
Who?
Sorry, my lord, the amount was disbursed by the land department through R.N. Borua and land clerk L.K. Raskwa. Senior land officer.
Respondent number 6, just check up respondent number.
Management witness number 6.
Management witness number 6. Dinanath Prasad Gupta. Who is he?
He is my lord.
Oh, he is the preliminary inquiry officer.
The person who made the preliminary.
Preliminary. So, Mr. Chaudhary, this preliminary inquiry, the signature, the statement of the Gambura, how was it done it in the domestic inquiry? How was it taken note of? Any material here?
That for that we have to go to the inquiry report at page 29.
Of the domestic inquiry.
Yes.
Mhm.
29. Sorry.
Page 19.
Page 19. The report is at page 19.
Just a moment, it may be here also. Is that inquiry? This was exhibited, exhibit 1.
Yes.
The inquiry proceedings, that file was exhibit 1.
It
From the
appears.
records I find.
It appears, yes, that is exhibit 1.
So find out whether the Gambura was there.
Exhibit number 1 MD, exhibit number 2 land chart, exhibit number 3 letter of approval, statement of surface compensation and emergency list.
Exhibit 7. Exhibit 7.
Statement of Kyong Laren Sumpu Gambura, exhibit 7. Management document 7.
Where?
Exhibit 7.
East one.
In before the, where? Before the domestic or domestic inquiry or the,
I think that domestic inquiry, page 20, Roshi will find that, serial number Roman 7. Statement of Kyong Larung Swencho Gambura that 9 persons in question do not exist or were living in his village or nearby area. He also had witnessed any payment to those persons. That has to be exhibits 7.
yes. Mr. Monto,
My lord,
done with.
your lordship, kindly see, my lord, one statement, my lord.
Why I am saying so? Preliminary inquiry was conducted by D.N. Gupta.
My lord.
He was produced as a witness. He brought on record this Gambura thing.
My lord. But my.
Page 146. And this is exhibit 1 before D. So this is also before the tribunal as an evidence.
But your lordship, kindly, what are the defense I have taken by that inquiry, my lord? Your lordship, kindly see page 20, my lord.
Page 20 of the petition.
No, yes, my lord.
Just a. And you had crossed him.
Yes, and that he does not remember about the details of the signature of the Gambura taken on the enumerated list since it is very old one of 1991.
Who has whose
and
statement?
also this is a job of the land department, my lord.
No, fine.
My lord,
Whose
taking
statement was that?
My lord.
Whose statement was that?
And that is exhibit 3.2, subclause 1, exhibit number MD 30, management document 13, management 14, management 14 and 16.
Page 20 of the petition. Page 20 of the petition.
Petition.
Just now. Yes.
So from very beginning, I'm saying that is not my duty, but who has the person there, my lord? Because my duty, my lord, how many copies are there? I have to sign there, my lord, in the same seat, my lord.
Come to page 21. Come to that 4.01 small 3.
In reply to the,
CEO's question, MW1 replied that Gampura had earlier signed as identifier of Mongol Uram. Subsequently, it was cut and changed to Nondo Sonwal. In case of exhibit DD1, the spelling in mistake was in the spelling of the name, and that is why it was rewritten to correct name of so and so, cutting out the. Whereas in the enumeration list, the name was completely changed from Mongol Uram to Nondo Sonwal. As a normal practice, cutting reviewing should be initiated so and so. The allotment has checked and confirmed that the name of the 9 persons were not there as occupied. Okay. Mr. Todri, can you, Mr. Kulda, get me some clarity, some judgment, wherein 11A situation, I'm convinced 11A can go, but the evidence which is there, because I find it, if you can just go through it once, it is exhibit 1.
Yes.
By the tribunal. Whether that will automatically be also an evidence before the tribunal.
Yes.
Some judgment. If that be so, the Gampura's non-examination may be inconsequential. Because that becomes an evidence.
my lord, that's true, my lord. But after my,
That's my doubt. That's why. Huh? Anything?
My lord, I'll try to find it. I understand your lordship's query. I want to satisfy your lordship.
but
My first query is non-examination of that either the what do you call that FSL
forensic
expert or the Gampura. How that point can be established, said to be established. Now, alternative, we find that the whole department inquiry material coming on is exhibit 1. So exhibit 1 means that becomes a part of the evidence of the tribunal. Now, whether the tribunal can rely on it. If it is reliable, then Mr. Monto will have to show me that DN Gupta's that statements that are recorded there are not trustworthy.
I get your lordship.
no, sir, that document is, my lord, a part of the domestic inquiry. my lord. So that domestic inquiry, that part, my lord, if domestic inquiry is held to be illegal, my lord,
That's
then
what.
how it can be brought into the, my lord?
That's why, Mr. Monto, if you can go through it.
My lord.
Mr. Monto. The last portion bunch, exhibit 1 is the departmental domestic inquiry records. Just check up, I may be wrong.
So all those evidences come into.
If it comes in, that part, that lacuna which I am troubling me may not be there. So just 5 minutes, I'll list it, then I'll reserve, I'll pass my orders. When can I have it? Thursday or Friday? Monday, whenever it's 10 minutes, only a clarification from your end on these points. 5 minutes?
Exhibit.
Now it comes in, that question that I was putting to Mr.
Exhibit 1.
Yeah, it's there.
Exhibit 1.
Let it be on Monday,
Monday, 12th. Mr. Kulta, if possible, just a small note. Mr.
On my side.
Small note. Thank you.
I'm highly obliged for giving us a presentation.
No.
I am actually, my lord, I am dealing with 2 or 3 cases in the department, my lord.
I have dealt
to
maybe
tell you,
with
my
one.
lord.
I have dealt with one. This is the second one.
And for me also probably this is second one, my lord.
Experts are there. That's why feeding on
That's
them.
why, yes.
But these are the matters you miss, Mr. S.N. Sharma.
My lord.
Mr. Chaudhary, on both points, if you can.
Yes.
Satisfy. Something.
Obliged.
Next.
Item 11.
3:30, you need not wait. We'll pass the order. We are dismissing your request.
Lordship, one more prayer, Lordship, regarding the salary, Lordship. He had worked during those periods.
That you make an application. If they find, they'll give it. They'll give it to you from the direct inspector of schools if required.
Regarding that one judgment, may I get, Lordship, please, Lordship. Regarding the salary part, Lordship, the judgment is regarding.
Give it to me.
Yes.
নামটো
Copy এটা দিলে। 2007-10-40. Lordship, the judgment 2007-1 GLT 409, paragraph 9 is the relevant part regarding the salary part, Lordship, that he had worked during that period. And therefore the state is entitled to pay him wages regarding the salary part, Lordship. For the period, Lordship, during which he served in the school.
Dispose. I'll do it. We'll see.
Much obliged.
10. Item 10.
I think start out with Lordship.
Departmental proceeding.
I'll start, my learned friend will come.
No, but this cannot be concluded today.
Yes, that is.
Next week I can't give a date. Thereafter I may not be here. Contrary. Paint. Misappropriation of paint.
Paint. I have a very limited submission with regard to the points. If I may just raise each point by point.
I'll not be able to pass.
Yes.
4:30, 3:30.
Four.
Let's this matters again. On the prayer of the parties, let's this matters again on 27 to 2024.
Your Lordship, can it be after March 10th?
March 10th. Okay, let it be on 12/3/2024.
Obliged, Lordship. Obliged, Your Lordship.
Item 15.
Yes. Yes. What is the instructions?
It was on, the question was on me, Lordship, if I can obtain a degree from Nagaland University being a teacher in Assam, Lordship. So degree was obtained on distance learning process on and I have appeared in Nagaland. So the degree was,
Will not do.
Lordship,
Yes, sir.
that is permissible as per the norms, Lordship, because as long as the
Without a
person-
course of study
Yes, Lordship.
in a college, sitting in Nagaland, they can't teach you here. You will have to go there. 2 years.
Lordship, it's a distance learning process.
Huh?
Distance learning.
Distance learning, that has to be approved. They will have to give an approve from the distance learning education council of
Distance Education Council, which is now Distance Education Bureau, Lordship.
Bureau. They'll have to give you a,
That approval is taken care of by the writ appeal judgment, Lordship. At that point of time, relevant point of time,
Hmm.
the
Second
university
last
had
para,
the
Your
approval,
Lordship.
requisite approval, whatever was needed to extend.
no, we'll have to have, you will have to show me that there was requisite approval for running the university is one thing. Requisite approval for DEC is another thing.
Exactly, Lordship. The writ appeal certainly
The
says,
second
Which-
last
which
paragraph, Your
paragraph?
Lordship.
Lordship will give me a moment, Lordship.
Yes. UGC, madam, what do you say?
Lordship, master degree is without the leave of the concerned authority, Lordship. Lordship, he took the master degree. Lordship,
Okay. If I give him the permission, will that master degree become normal?
No, Lordship, off-campus degree, as because he took,
Tell me that.
Lordship, off-campus degree is invalid,
He
Lordship.
says that the division bench has said that that is also validated. What do you have to say on that?
Lordship, the provisional recognition was given in 2008. They have applied, which
Lordship,
recognition-
after Yespal, Lordship,
Lordship, the initial, the course, the university was set up in 2006. In 2008, provisional recognition was given
By the
by the UGC.
UGC.
Lordship, then 2013, they have removed it. First, after the report of a committee stating that, we did not have, the
When
university
did
did
you
not
have your degree?
I had in 2015.
15, during
2000
that period of removal.
After the period of removal by the UGC, which has been held back by the Honorable Single Judge of this Honorable High Court, then which was gone on the writ appeal. Writ appeal after the judgment of this Honorable Single Judge, Lordship. Lordship takes up the last paragraph, 16.
No, I'm not on that.
Lordship.
Now show me that the university had an approval of the DEC also.
That may be your.
Then otherwise, anything you do with the university, fine, no problem.
Lordship.
But DEC approval is required. Otherwise, that
On the-
ODL course will not be.
On the relevant date, Lordship. Lordship, any date I'll come up with that instruction. Lordship. What? Lordship, it takes up the paragraph, page number 4 of the judgment, Lordship. There's only one statement with regard to DECs. They've requested, but no formal notice came.
Page number?
4 of the judgment.
Okay, now tell me one thing.
4 of the judgment.
This court, after holding everything to be okay, had remanded back the matter, single judge had remanded the matter to an expert committee. What happened thereafter?
They have filed a writ appeal, Lordship. Now they have filed this writ appeal, Lordship. This is a writ appeal judgment.
This is a writ appeal.
Lordship. After the writ appeal judgment is, after that, I have no, writ appeal
Because
judgment was
this-
passed in 2020.
Writ appeal is dismissed without interfering with that portion of.
Lordship.
So I reiterated that portion.
Lordship.
Go and have it before students are suffering, go and have it before a
Lordship.
committee.
Lordship.
Now, without that committee giving an approval, how can this degree of yours be revalidated? You come to the judgment.
Lordship. That is not, it is, Lordship, that has to come from the,
Passing something, granting a nonsense, so was without basis by coming to the.
Global Open University to be a syllabus.
Okay, what is your, otherwise the grievance here, what is your
at that
deprivation
point,
that is
when you
caused?
file the writ petition, Lordship, it is grievance was with regard to not appointing me as a principal in charge, Lordship. But at this point of time, the regular principal sees the regular principal, the private respondent, Lordship. So that grievance will not be valid at this point of time. However, by the same order, my MA degree has been invalidated, Lordship. So now the grievance only remains with regard to my degree being valid or not. Lordship, if the judgment of Honorable Single Judge had also quashed the order by which it
Quashed, but for giving validation, it has asked that expert committee will go into it.
Lordship,
Nothing has happened. So how can we validate your degree?
as that,
We'll consider.
Lordship.
List this matter again on 12/2/2024 for further consideration.
Lordship, it may come admission column, Lordship. Because it's coming in order, no steps, Lordship. As per number 6, the steps were not complete with regard.
6 has appeared.
6 has something, no, 6 appears. It was, then it maybe.
It is complete.
You have not taken fresh steps also.
That last time we prayed, Lordship, but that was
Who is respondent number 6?
the private respondent.
Huh?
The principal.
You are appearing.
Yes,
Miss G. Swami, Lanik Council, appears on behalf of respondent number 6. Also, accordingly, service on respondent number 6 is complete. raised this matter for admission hearing on 12/2/2020.
Also, my name doesn't show in the list.
Mr. Name of Mr. D. Decker. Learned counsel for the petitioner be reflected in the cost title. Reflected in the cost title. Fine.
Highly obliged.
Obliged.
Item 33.
Yes,
My lord, this is complied, Your Lordship.
complied with. Give me. Yes, madam. Anything more left? They have sanctioned your money. Send it to the. Close it. Miss. 87P, learned counsel for the petitioner. A learned counsel for the respondent has placed before me a communication it received in a communication received by her from the secretary to the government of Assam Department of School Education, by which it has been intimated that the area salaries for the of the petitioner for the period 28/9/2000 to 6/9/2005 has already been sanctioned in compliance of the directions passed by this court wide order dated 14/3/2019 in WPC number 1288/2014. Accordingly, the directions, a violation of which is alleged in the present proceedings, stands complied with. Accordingly, the contempt petition stands closed. Okay, the communication as produced by the learned counsel for the petition, learned counsel for the respondent is kept on record and marked as X. Okay. Now,
Obliged.
H. Arunaidu, Arun. Itu muk di dia, 36 to multiply.
For hearing item 36.
Yes, Mr. Burmia, what is it?
May I please, your lordship, my lord, matter relating to selection and appointment to the post of junior instructor, lordship, in different polytechnics of Assam, lordship. Lordship, petitioner.
Somebody was to get instructions, yes.
Yes, lordship, your lordship, on last day, lordship.
You have got these instructions, Mr. Any person having pumping trade qualification appointed as junior. Oh, that, yes.
What is
Pumping, yes. Got it. There was shortlisting made, but nobody from your trade came in.
Yes, lordship. Although, lordship, we appeared up to the final selection.
Final selection, okay. As per so. So after this, what is there, Mr. Burmia? Just go through it.
So, my lord, your lordship may kindly peruse.
Have you seen that instruction? So the case of the government is that you did not obtain requisite marks.
Yes,
And
Lord.
during the last deliberation we had, there was a cloud created whether some other persons have been appointed. So that's why Mr.
No, no.
Gogoi was directed to take instructions.
Yes, Lordship. But they have again stated that no one could obtain the requisite marks.
Yes, that is already there in page 36.
Yes, Lord, that was already they have stated in the in their
that's it.
affidavit, Lordship. But fact is that, Lordship, in my category, Lordship, in my trade, Lordship, no one was appointed. Lordship.
No one was appointed because nobody was qualified.
No,
That's all.
Lordship, because in the advertisement, Lordship, there are no such criteria, Lordship, that the.
You tell me the,
Cut
show
off
me the,
marks,
show me the pleading to that effect.
Yes, Lordship. Well, at paragraph 9, Lordship, 9 onwards, Lordship, I have stated, Lordship.
Okay.
Lordship,
Where
I
is the
cannot-
advertisement?
Sorry, Lordship.
Advertisement,
Advertisement, Lordship. Advertisement, Lordship.
page 21.
Page 21, Lordship. And page 22, Lordship, clause 16 is the selection process, Lordship.
Mr. Gogoi,
Lordship.
now this cutoff mark thing,
Lordship.
how it came to be prescribed? Because they scored some mark in the selection process,
Lordship. Lordship.
but you found that because you can't compare plumbing with somebody else.
Lordship.
It should be independent,
Lordship.
right? Why this happened?
Lordship, the advertisement was
You
not.
come to
issued-
page 36 of your affidavit.
Lordship, Lordship, Lordship. 36. Lordship.
You can't, none of the 5, have you got it? Internal page 4 of your affidavit.
Lordship.
None of the 5 candidates, including the petitioner belonging to so-and-so, could obtain the requisite marks.
Lordship.
The petitioner obtained a total of 33,
Lordship.
whereas the last candidate selected in the same category, male,
Lordship.
secured 59
Lordship.
from information communication technology system.
Lordship.
But how do you compare this with?
Lordship, this is as a whole, Lordship, not that advertisement.
no.
Kindly close the advertisement, Lordship.
That's what I want.
Advertisement, Lordship, there is no distinction, Lordship. Advertisement, there is no distinction, Lordship. Advertisement as a junior instructor, Lordship.
So all the 25 posts were filled up.
Lordship, Lordship.
You mean to say you selected people,
Lordship.
whatever their trade, they come in.
Lordship.
If they cross that, you
Lordship.
give. That's your case.
That is the
Yes.
case.
What
That
do
is the case.
Yes, Lordship. But
What, with the advertisement, what error was made?
Yes, Lordship, in the advertisement, there are no error, Lordship.
No, what Mr. Gogoi and also relevant from 36.
Yes, Lordship.
That whatever marks the people got,
Yes, sir.
top people they brought in and whatever category they had,
Yes.
they placed him in that places.
Lordship,
Say you are plumbing, you'll be placed plumbing. I am maybe mechanical, I'll be placed in mechanical, somebody is computer. But that choice was made on merit. It was not category wise. It was one examination for all.
One for all.
one
for all.
examination, Lordship, but final proficiency test is for different persons.
Fine, maybe,
Yes, Lord.
maybe.
Because Lordship, in the advertisement itself, Lordship, the qualification which was prescribed, Lordship, that were Lordship, Lordship passed HSLC or TSLC having.
No, Mr. Barmia, in the advertisement, there is no distinction between plumbing. It's not breakup. It's
Yes.
only post of junior instructor.
Trade-wise, Lordship, advertisement was not made, Lordship. It is definitely, Lordship. But Lordship, in the qualification column, Lordship, the specific trade should be required, Lordship, from the ITI, Lordship. Because, Lordship, as per rules also, Lordship, the qualification.
And see, they have segregated you for plumbing test because that would be a different thing. But the merit list was one, right?
This is for assessment, Lordship. Segregation is for assessment.
Assessment, huh?
That's for assessment, Lordship.
Come to page 30. What is this? Declaration of final return, so and so. And junior instructor, so and so. Okay. Scientific assistant, junior instructor. Roll numbers of selected candidates, so and so. Number of posts 24, 4. And this is Mr. Gogoi, you are saying across the categories. Page 30. Just see page 30.
30, Lordship.
Across the categories.
Only Lordship, unreserved OBC, SC, ST, that part is there, Lordship.
That's different.
Because, Lordship, in my reply affidavit, Lordship, I have compiled one worksheet, Lordship, wherein I have shown that, Lordship, Lordship, most of the Lordship trades already covered, Lordship. From all the trades they have appointed, Lordship, but only
But
from
that is
plumbing.
again, they say that it's on merit. You can show somebody is scoring marks lower than you.
No.
Not a reserve candidate
No,
was
Lordship, I
appointed.
shall not be compared with Lordship, other trades, Lordship.
Can't help it. That was the selection process.
Lordship, then your Lordship may kindly fix it on next week, Lordship.
No. We are closing it.
Kindly, Lordship, because Lordship, there are some instruction is required, Lordship. Next week, Lordship, a date may kindly be fixed.
5 minutes. I'm
Lordship,
fixing
next
it for
week, kindly
delivery
be
of
fixed.
orders.
Lordship, because I have an instruction to.
I will,
Senior.
I am fixing, no, senior, 2 days, we have given you enough time.
Lordship.
I'm fixing it on 15th. If you have anything to say, 5 minutes I'll give you before that. I'll pass orders on that. List this matter, heard the parties at length, list this matter again on 15/2/2024 for, 16/2/2024 for delivery of orders.
Lordship, just I am willing to judgment, Lordship.
Mr. Peter, you have marked the paragraphs?
Lordship, let me get.
Paragraph that was the only doubt I was having. Today I'm clear. Yesterday I could not decipher that.
Because Lordship, Lordship, my trade cannot be compared with other trade.
It need not be, but they did not go trade wise. They went whole hog.
Because I have.
Whoever they, that you
my
challenge the
application in
advertisement.
Plumbing trade, Lordship.
You challenge the advertisement.
No, Lordship, because.
Challenge the advertisement. We'll entertain. Okay. File to muk didibo. List of
Lordship, instruction plays a record.
Instruction is on record. That is it. Place it on record. The instructions as produced by the instructions received by Mr. K. Gogoi as produced by him today is kept on record and marked as X. X. Yes, Mr. Sogia. Item number
33, my lord.
Yes, Mr. Mazumdar. 33. Mr. Mazumdar.
Yes, I have given.
Where?
My lord, Lordship has disposed it that we have.
You're writing a junior was there.
I have given the copy to him. He's there, my lord.
Oh, she was there.
And I have given a
Close
copy
the
to the
matter.
other person.
You have been given the money. Sanction, sent to AG. What more is required?
There was 2 directions, my lord. Along with interest, they have not given the interest part. In the direction, my lord.
Okay. Oh, file to deduction
That
33,
that I'm not aware.
33.
That I am not aware.
That I was also not aware. Let me see. Hey, 33 to me, na? Exchange.
If there's an interest.
It's 13 my lord.
Okay. No, no, no.
Page 14 is the interest.
Likho, usko kato. Thank you for pointing it out.
No, no.
Mr. Nair se likho. Mr. R. Mojumdar has produced. H. Tarangpi, Ms. H. Tarangpi has produced before me a copy of a communication dated 5/2/2024, by which the area salaries of the petitioner as directed by this court has been sanctioned for payment, and the sanctioned order has been sent to the Accountant General A&E Assam for disposal. However, it is seen from the order dated 6/8/2015, this honorable court, while directing the authorities to release the areas of pay for the period, areas of pay of the petitioner for the period 28/9/2000 to 6/9/2005, had held that in the event the said amount is not paid within a period of 3 months, the same would carry an interest of 12% per annum from 28/9/2000 till the full payment thereof is made. Mr. H. Tarangpi, I'm putting her name because she had Tarangpi, shall on the next day apprise this court as to whether the amount now sanctioned to the petitioner also includes the interest component as awarded by this court.
There was another direction in the review petition, cost of 50,000. That is also not included.
Again, this much that is enough.
Oh, my lord.
Substantial by compliance.
Allegedly.
Level